Hi, everybody. How are we? Happy New Year. Well, I guess not yet, right? Not yet. Technically, not yet. I am fighting a cold. Well, let me put it this way. I started to fight a cold. That thing kicked my butt. It won that battle. And I'm just going with the flow. It's good to see everybody. So yeah, if I sound funky, that's why. If I break out into a solo of Smelly Cat, just go with it. Just go with it. Enjoy it. All right, so I put together some clips for you guys that what I like to call best of Brooks, and I don't think I could get all of them in one live stream. I'm just going to be honest because he's so ridiculous. We've got weeks of material here, but I broke it down into some things that I had. And with that being said, let's get started.
The court will call State of Wisconsin versus Daryl Brooks, case number 21 CF 1848. May I have the appearances, please?
Good afternoon, Judge Sue Apper, Leslie Basie, and Zach Wichow, appearing for the state of Wisconsin.
Good morning, Your Honor. My name is Daryl Brooks Jr. My name is Daryl Brooks Jr. Say my name. Daryl Brooks Jr. I'm in the say my name. Daryl Brooks Jr. It is by special appearance, and I would like to ask, if it pleases the court, that someone can please render the account for me at this time.
All right, thank you. Be seated.
Extremely close with the district attorney's office during the entirety of this matter. Would that be fair to say?
The district attorney's office has been involved in this investigation since the night of, so we have worked closely.
So would it be fair to say extremely close, seeing as how you've been present for the whole trial pretty much?
Can you define extremely for me?
I would like you to define it. Extremely.
I'll answer yes if that helps.
All right, and then anything from you, sir?
In regards to this,
Any other preliminary matters that you are asking the court to address?
were my filings actually filed? I don't understand the proceedings. And I think that should be stated for the record. If I'm telling you repeatedly, Your Honor, that I don't understand, you can't force me to understand. I'm curious. Some of these, judging by the reports, how are some of these answers allowed to pass when they're coming straight from reports made by the people on the stand? Very curious.
I don't understand your question.
Just for the record, Your Honor, I would like the record to reflect, is that a judicial determination that you are making?
All right, Mr. Brooks, do you have a 13th subpoena? As we discussed yesterday, you wanted to call 13 witnesses. I told you had until this morning to fill out another subpoena and give it to the state so that they could review it.
Yes, I do.
All right, can you hand that to the bailiff, please? I'll just take a look at it quick. Mr. Brooks, I'm reviewing this for completeness. And you have simply put on here, State of Wisconsin plaintiff. That's an entity. You have to name a person, sir. All right, Mr. Brooks, any further topics by you?
Am I muted?
No, you're unmuted.
I still hadn't even gone through the entire witness list from the prosecution. It was 30 plus pages. That's a lot of names.
Have you ever had any interactions with this entity, State of Wisconsin? That's a violation of my constitutional rights to try to force something upon me. That's coercion, Your Honor.
Where'd you get this video from, sir?
Objection leading.
Overruled, the witness may answer.
From Mr. Brooks' social media account.
Okay.
The video wasn't even in the exhibits that I received. I actually didn't even receive them. They
Mr.
were
Brooks, please
obtained.
stop.
Video is
The
ridiculous.
juror will disregard his statements. He's not testifying.
Superstar.
I just, to be blunt, which I've been since the beginning of this trial, obviously, I see the whole strategy here by the prosecution. I see right through it.
If I have you stay in this courtroom, are you willing to follow the rules of decorum and courtesy?
I do not understand the question you are asking.
Do you have any other issues you want me to address?
Just very, very quick. I still don't understand the nature and cause of the charges against me, Your Honor, and I still would motion for, or tennis motion for the jurisdiction to be proven, the subject matter jurisdiction. And also a motion for finding of fact.
Your requests are all noted for the record, and for the reasons previously stated on this record, I'm not going to answer those requests any further. They've already been denied. Mr. Brooks, you may ask questions of Detective Casey.
Objection, I don't consent to being called that name. Yeah,
Noted. Do you have any questions for the witness?
This, when did this video, when was this made a exhibit? Because I don't have it.
Objection, that's not a question for the witness, Your Honor.
That was a question. The question. When was
Sustained
this
as the
video
form
made
of
an
a
exhibit?
question.
When was this video made an exhibit? That is a question.
I object to the question directed at the witness, Your Honor. It's beyond the scope of his knowledge.
Well, he said he saw it.
But that's not the question asked. So you can rephrase your question if you want to.
When did you see this exhibit? When did you see it?
Am I answering when I saw the video for the first time?
Yes.
Objection, Your Honor. Why is something always funny at that table?
State's directed to avoid laughing commentary. I didn't see it, so I can't further comment. I was looking at
All these
the
cameras
witness.
in here, don't nobody ever see
However,
nothing.
both parties to show
Come on, man,
decorum
this is not fair.
and restraint. I'm
So
not
is you-
hearing a request from you at this time. You said you wanted to raise a legal issue. What's the legal issue?
The legal issue is how is the state allowed to coach the
You're
people getting on the
assuming they
stand?
spoke to them and coached them.
It's obvious. I'm not stupid.
Well, I disagree with that, sir. Are you willing to not interrupt the proceedings with disruptive behavior?
I do not understand the questions that you are asking.
Any other issues at this time?
Yes, I do. The statement of particulars that hasn't been responded to by affidavit. The notice of special appearance hasn't been
I
responded
direct
to.
your attention to the Barnaby decision, sir. The court's not going to be addressing that topic any further.
I saw the video within a few days of Mr. Brooks being arrested. I've reviewed it since then a few times. I reviewed it yesterday and again this morning, and now in court again.
You said you reviewed it yesterday and this morning. If you had seen this video numerous times before yesterday and today, why did you feel the need to view it yesterday and today? First of all, at 9:25, I would like the record to reflect that the prosecution was making dispiriting remarks and gestures in pursuant to what just happened. I don't appreciate it, and I think that that is very disrespectful.
I believe you're choosing not to answer them,
You can
sir.
believe what you want to believe. I believe that you hiding stuff from the jury. I believe you haven't been impartial or fair. You haven't let me even enter anything into evidence, which is my right to do so. And to your knowledge, why was this video never brought up in your earlier testimony?
Objection, that's a
Grounds.
misstatement, Your Honor.
This is mine, by the way. This is mine.
Next question, please.
I don't got no more questions, man.
All right, thank you.
This is mine, by the way. I don't understand. Nope.
The jury deserves to know who the plaintiff is in this matter. I think it's fair to them, if they're to make an informed and intelligent decision, they should know who the plaintiff is.
Do you think I would sit here and be this irritated?
Mr.
by
Brooks, I need to
something
make
that
a
saw?
record, so just please sit down. There's no need for you to stand at the moment.
I feel like standing right now.
Please sit down.
I feel like standing.
You opened up the door through your cross-exam of Detective Casey about his ability to identify you in that video. You opened up the door for the state to show that video because you directly attacked the credibility of Detective Casey through his knowledge of it and the identification by him of you in it.
She's been laughing and making comments under her breath the whole time during the whole trial, and I never said nothing. I don't know what's being said, but I can tell that it's directed towards me. I'm not an idiot.
Then you need to provide me with the legal basis for that, sir.
So I'm supposed to just come off that with off the top of my head?
Yes. All right, we are back on the record. It is 1:01 p.m. State versus Brooks. Appearances are as they were before. I would note I have instructed, and Mr. Brooks is present in this courtroom. Prior to the, I understand your objections
I don't
noted.
want to be in this courtroom.
If you would like to go back to the other courtroom, sir, you may, but that is a choice that you would be making. I am not requiring you, I'm not forcing you at this time.
So you're not holding me in contempt?
Sir, I am not requiring you or forcing you to go into the other courtroom. Well, given that he won't answer the questions directly, for now he is to remain in this courtroom.
I'm requesting to not be in this courtroom.
But you won't go through, you won't answer my questions regarding that, sir.
I did. I told you I don't understand.
That's not answering the question, sir.
You asked me a question, I answered it. I don't understand. How can I answer something that I do not understand, Your Honor?
Your
But it
rights
doesn't
are not
matter what we
unfettered,
believe,
sir.
Your Honor. I'm merely stating a request to not be present for these proceedings. I cannot answer the
Sir,
questions you are asking me because I don't understand them.
You understand your right to be present in the courtroom. Are you telling me you
I don't understand
that
anything because I've been over there all morning.
to the place that you are requesting to go back to, right?
You sent me into the other courtroom.
You're right, I did.
Right.
So that's a tacit
All
agreement
rise
that you
for the
don't.
jury, please.
It's a tacit agreement that you don't have to answer questions as a public servant, right?
All right.
But when I'm making a request to avoid the drama and all that,
Sir, the only one with the drama is you.
so let's
To the other
make the record
courtroom,
correct.
and we
I'm
have
the one
the
that asked
audio
when we came in here, Your
and
Honor.
video working appropriately.
I asked when we came in here to
Madam
be
Clerk,
present
we'll
from the
have
other
to do it
court.
by Zoom because we may have to utilize the share screen in order.
We don't have to utilize no serious screen because I'm not going to participate in no proceedings that I don't
The
understand.
documents.
I told you I don't understand
We're
a
in
million
recess until
times.
we get the courtroom set up.
No, we don't have to be in recess. I don't agree to it.
Yeah, would that be, will my objection to that be noted for the record?
It is.
May I request a legal reconsideration of your ruling, Your Honor?
Denied.
May I request a written finding of fact for your ruling, Your Honor?
Denied. Just for the record, it's my understanding that the verdict forms were put in the garbage by Mr. Brooks and they remain in there. Well, I trust the state will object when appropriate, if
It's gonna
appropriate.
be a whole lot of objection then because I'm gonna tell the truth. Don't try to come with your slick words and don't put words in my mouth.
Sir, I am not being slick. I'm trying to
You've
preserve the integrity.
you've been slick. You've
All right.
been slick. How's that lawful
Sir,
law?
if you choose
How
not
is
to
that
give
lawful
one,
law? How's that lawful law?
you didn't even let me get my sentence out.
You always want to make a incorrect record. Go ahead, make your incorrect record. Go ahead. You can't rush me to judgment, or you can't practice law from the bench and tell me when I can do something and when I can't.
Mr. Brooks, I actually can, under all of the rules of procedure. It is my
Okay.
job to make sure there's effective
Okay.
and efficient administration of this trial.
So
You are,
then I should be allowed to. Then if that's the case, and I should be allowed to tell the jury what they need to know, which is the truth. That they have the power. They have the power to nullify laws if they don't agree.
You
with
are
them.
absolutely not allowed to tell the jury that. There's a jury instruction that I will have ready to go if you even attempt to raise the issue of jury nullification, sir. You have absolutely no right to raise that. That is clear under the law.
I can raise what I want to raise.
It's clear to me you've done your
What
homework.
you talking about? I don't care what you're talking about. I'm gonna let them know that they can nullify any law they don't agree with.
It is a new part of the day. I thought it appropriate to have you brought here.
Why?
And only if you forfeit your right by conduct will I put you back in the other room.
So you don't address subject matter jurisdiction for the record, or are you gonna state it on the record?
Okay, then with that, there's Bruno.
Subject matter jurisdiction, Your Honor.
The court's declining to address that further. I stand by my written decision that was entered last week.
So we won't be proving it for the record?
I stand by my written decision that was entered last week, sir.
Judicial determination?
It is a judicial determination.
We would just like to make a record with regard to the concern Mr. Brooks had yesterday about the juror that he believed he recognized from his initial appearance that may have made some type of hand gesture to him.
The juror that you suspected was the woman who made an inappropriate gesture toward you at the initial appearance. They are not the same individuals. I've been able to confirm that. I know the identity of the woman who did what you said, and it is not this juror.
Is there any way that I can be sure of that?
I'm declining to address that on the record for the reasons I've previously provided to you, not the least of which is I have addressed that by way of a written decision.
And it hasn't been proven for the record. You
Your
have to state
objection
it
is
on the
noted.
record. Can I go back in the other courtroom? Because I'm not going to do this with you. I'm not.
Mr. Brooks, I do want to go over
We don't
the
have.
jury instructions.
I don't understand the
verdicts.
jury instructions. I don't understand anything that's in these proceedings, and I'm not going to participate in something that I don't understand.
That's your choice, sir.
May I please go back into the other courtroom?
So that's why I cut.
Hi, Brenda. Thank you so much for joining, honey. Welcome to the Hee Hee and the Key Club.
Because there was not anything that you were connecting by way of relevance.
With all due respect, Your Honor, a lot of the questions I ask are
Stupid.
objected to. It seems like I can't even get to the questions that need to be answered.
Sir, many of your questions go to these sovereign ideas that are frivolous arguments about the plaintiff and all of that. Ask relevant questions, they'll be answered.
You made reference to questions I asked and being, you said something to the effect of sovereign things. I don't understand what you mean by that. I have no anticipation on your rulings. I'm not trying to sit here and I got enough work to do on the fly. I'm definitely not trying to sit here and trying to anticipate what will be objected to, what will be ruled on in any way. I'm merely just, it was understood that this would be a whole new thing for me to do. I apologize if I'm not as polished as I should be working on 3 days' time before a trial. We see all the work that I haven't even gone through.
Mr. Brooks, the jury's coming back in. Again, you could ask questions to lay a foundation
all of a sudden the
with
state
these
don't got,
witnesses.
all of a sudden, for the first time in trial, all of a sudden now they don't got no cross. That's clearly a rush to try to get through the case. Hurry up. We just gonna let these people go.
Well, this is argument.
Come on, man.
This is argument on your part,
I
sir.
see
It
through
is pure
I
commentary
just
at
want
this
that on the
point.
record. I see through it.
And your
Nice try,
see-through.
but I see through it.
That was my understanding that Mr. Brooks did receive the medical attention that he was seeking over the lunch hour. So I just wanted that on the record.
Has absolutely no basis in fact.
Yeah, I know that's what's being done. So, again, I don't understand nothing you just said, but I don't. How can you deprive me of my constitutional right? How can you trample on my constitutional right?
Mr. Brooks, on the issue of medical attention, did you see the jail nurse or other medical personnel during the lunch hour yesterday?
Yes, I did. I received a cleaning of my cut and a bandage.
All right, thank you.
Oh, I'm sorry. I was getting to the other parts of the injuries. They
Go ahead.
viewed the bruises that I have on my arm and legs as well. I don't know what's gonna happen behind that, but I was looked at.
Might go into medical.
All right, thank you.
May need surgery.
They're your witnesses, sir. If you believe...
So I'm gonna start asking every witness up here that they seem just to mysteriously now not have any cross for. Have they been coached to answer the way they answer?
Does not appear to me that any of these injuries are interfering in any way with your ability to be here today and assist in your own defense. So that's good.
Yeah, I'm just a little tender, just a little sore. So
All right.
I find it very funny that these are their reports, and now all of a sudden you can. Oh, I saw the person in the car. Oh, but
Mr. Brooks,
I
this
saw
is
them
an
reach
attempt
for
by
something.
you
Oh,
to
I don't.
delay these
I don't recall what
proceedings.
they had on.
Mr. Brooks,
You can
there's
recall
no
seeing
purpose
somebody
for you
reach
saying
something
this
and
right
don't
now.
know what they had on. I find that
All right,
very.
I'm having the jury brought
man.
out. I'm instructing you to
Come on,
avoid
man.
the commentary when the jury comes out, or you will
I didn't
forfeit
say-
your right to be
I didn't say
present.
nothing. You.
All right.
can you show proof of that,
sorry?
Your Honor? Verified?
Give them what?
Can you show a verified affidavit of that?
No. All right.
So as long as the jury's out, we should probably discuss that. I would like to provide the defendant and the court with a copy.
So that had
of
to be
the-
said. So it's the defendant.
That's not how it was said.
That was how it
completely
said. You want to run the
disagree.
record back?
Is that a judicial determination?
All right. I believe the jurors are coming out. All rise, please.
Are you going to answer that, Your Honor? Or is
No.
that a tacit agreement?
Mr. Brooks,
So I'm the only one. I got one. I
Mr.
got one
Brooks.
ear that work, and I heard that.
this
Come on,
is
man.
to benefit
man.
you so
No,
that
it's
you
not.
understand
Ain't none of
your
this to benefit
witness
me, so let's be
has
clear
a
about
prior
that.
record.
Entering into anything with is deceptive in nature. Just right off the bat, that's deceptive in nature. Why would you enter into something that you're obviously not supposed to be into?
You can, based upon your choice and your request, I'll make a finding that he's forfeiting his right to be present in this
I didn't forfeit
courtroom.
anything. I asked.
I understand you've
So I
asked,
didn't-
but
I
I
didn't
feel it's
forfeit
important to
anything.
also make a finding based upon your conduct.
Based upon what kind of me asking?
Are you willing to expressly waive that right on the record right now?
I'm not gonna expressively waive anything. Come on, man. Like, I don't know who y'all be thinking y'all fooling. I accept for value, return for value, this document.
One more interruption and you're going to be...
Anyway.
I did bring these boxes up. I have not had the time to go through everything in there. As you can see, it's a lot. That's putting it minimal. A lot. So I have not had the time to go through everything that's in there. I'm winging it, Your Honor. Your Honor, it has yet to be proven for the record. And upon your refusal, that would be looked at as dishonor.
I'm not addressing it. The jury's coming out.
So is that a tacit agreement that you don't have to answer any questions as a public servant, Your Honor? Therefore, that's dishonor.
The state of Wisconsin is an entity, it's not a person. The state of Wisconsin cannot testify at these proceedings, so the subpoena should be rejected, Your Honor.
Your Honor, on the grounds that every document that was filed in this matter stated that the state of Wisconsin was the plaintiff, which would lead me to believe that the state of Wisconsin is who's bringing the claim against my client. I do represent myself pro per. I would like that stated for the record. Like the record to reflect that, not pro se.
The record will so reflect your choice of term to describe your appearance today. Are you willing to engage in a colloquy regarding your right to be present and a knowing and intelligent and voluntary waiver of that right?
I am not going to consent to anything that I don't understand, and I will not answer any questions that I don't understand. I'm merely making a request to not be present in these proceedings. I'm requesting a written judicial finding of fact and conclusion of law on this issue for the grounds that I just stated. It was seen, based on the Sixth Amendment, that I'm not being awarded the chance to face my accuser, which I should be awarded that based on the Sixth Amendment. If I'm not able to face my accuser, then how can the claim even stand?
And to be in the other courtroom.
Again, as I've stated numerous times now for the record, I will not answer or comply with anything I do not understand. I'm not making a voluntary waiver of anything. May I state for the record, Your Honor, that I have not even seen a complaint in this matter, and the jurisdiction still has yet to be proven, which is another thing that needs to be challenged. There has not been proven that there's subject matter jurisdiction as of yet. There's no verified proof of it. There's no verified proof of even a claim, especially if I'm not allowed to face my accuser. And I don't understand how you can make that judicial decision, Your Honor, when it's clear discrepancies in the paperwork of this matter. Like I said, I have yet to see jurisdiction be proven. It has not been proven. I have yet to see a complaint. I have not seen that.
All right. Start with the jury instruction.
You'll start with subject matter jurisdiction?
No, I've declined that already, sir. I'm not going to address
Under
that
what
further.
law? Under what lawful law?
We are in the middle of trial. Your objections are noted. We will continue today with the jury trial.
For the record, may I respectfully move for interlocutory appeal on this matter, Your Honor?
Your request is noted for the record. I'm not an appellate court, sir.
For the record, may I move to stay these proceedings until this instant matter is adjudicated by a court of competent jurisdiction?
Your request is denied.
Based on what law or fact, Your Honor?
I've previously addressed the issue, sir, based on law of the case.
Are you making a judicial determination that I'm not awarded my Sixth Amendment right to face my accuser?
I'm not making any such determination here today. All right.
What law or fact?
I'm going to turn to the district attorney's office. Do you have a witness available?
Yes, we're ready to proceed, Your Honor.
All right, our jurors here. All right, the jurors will be brought out, sir.
Your Honor, with all due respect for the record, you're avoiding my questions.
Mr. Brooks, I've addressed the issues that need to be addressed this morning. I've also addressed the same issues probably every day we've been in court. I know you may be dissatisfied with the response that I'm providing to you, but my responses stand.
It's not a dissatisfaction, Your Honor. It's a lack of understanding, which I don't have. I don't even understand the true nature and cause of the charges. And without...
Mr. Brooks, you've been made aware of them multiple times.
I do not understand them, is what I'm saying.
I encourage you once again, if you don't understand anything, to seek the advice of an attorney. I cannot give you legal advice.
I'm not asking for that, Your Honor. I'm merely asking why are my constitutional rights being prejudiced? It states under the Sixth Amendment that I have the
Sir,
right.
I've already addressed this. Okay, we're not going to have any further argument on this topic. All right, your Sixth Amendment rights are being honored no differently than any other defendant that has appeared in my court.
Have any other defendant not been awarded the opportunity to face their accuser?
You are facing your accuser, sir. Every single witness who's been on this stand, you have cross-examined.
None of those witnesses are making a claim. None of those witnesses are the plaintiff. None of those witnesses are identified as the injured party. An injured party has to make the claim, Your Honor. A
Sir,
living.
it's my opinion that your belief as it relates to that is mistaken. It's not a lawful argument, and it's frivolous. I've directed your attention once again to the Beneby decision.
Is that not a federal case, a United States?
You're asking me for legal advice. I'm not going to provide that to you, sir.
I'm just asking what kind of case it was. Was it federal Supreme Court
It's a
case?
Seventh Circuit Court of Appeals case. We're in the Seventh Circuit, sir.
But you just stated that you're not a court of appeals. But you're citing a court of appeals
No, but Court
case.
of Appeals case law applies to this court, sir. I'm bound by legal precedent from the various courts that are above me.
And you're still not explaining how I'm not able to face my accuser, which is my Sixth Amendment constitutional right.
Sir, I'm not going to explain the law to you. I've made my decision. It stands.
I'm not arguing that part of it, Your Honor. I'm just merely stating for the record.
Yeah, I heard the door. Okay, thank you.
I'm merely stating for the record that I should be awarded my Sixth Amendment right to face my accuser.
Your objection is noted, sir, once again. We'll continue this morning. Thank you.
None of the witnesses that testify are the accuser. None of the witnesses that testify are the injured party, which a claim has to be made by a living, breathing human being.
Sir, I think you're confusing civil law with criminal law. That's what I'm saying.
No, I'm confusing. I'm not confusing any law. The Constitution says that I have the right to face my accuser. And under the Sixth Amendment, I'm not being awarded that constitutional right. I think that definitely needs to be on record, and that definitely is the issue that needs to be raised.
Your objection is noted, sir. If you believe I've erred in that regard, you can raise that issue on appeal if you are convicted.
May I put Your Honor on notice that I intend to appeal that decision?
Your statement's noted for the record.
Is that a judicial determination I will not be able to face my accuser, Your Honor?
I have not made any such determination, sir.
Will you be making a judicial determination?
Sir, I have not made any kind of determination that your Sixth Amendment rights have been violated. On the contrary, I believe this court has honored those rights.
Even with me not being able to face my accuser, which is the state of
Your
Wisconsin.
position is noted, sir.
Is that
Noted
a
for the
judicial?
record. I've already addressed it.
Is that a judicial determination?
Sir, the record speaks for itself. I'm not going to answer that further. I've answered it multiple times.
Is it a tacit agreement?
It is not.
Then I should be awarded my Sixth Amendment right to face my accuser, or a judicial determination should be made.
Record to reflect that the jurors are coming in for the morning. Good morning, ladies and gentlemen.
The record should also reflect that I received no answer to that question.
And then you forfeited your right to testify in your behalf. I'm not going to revisit those, sir.
I'm not asking you to revisit them, but I'm just they weren't correct. For the record, accept for value and return for value these documents. I'm confused. I do want to state for the record that I have no involvement with this. I'm really like shocked like this even came to light. I will say, just by skimming through it, these are definitely things that have been talked about in the court. So I
I mean, common sense would say that this came from someone that has either been in the court to hear what goes on in the court or a jury member. There's no other way.
Well, actually, the proceedings are live streamed worldwide, Your Honor, available on YouTube worldwide, so I don't agree with that assessment.
Whew. Is he wearing y'all out yet? We're not done. Hang on. I got to switch over to another stream because I've got more coming up. I just had some stuff done. But I did want to play this part one more time.
Good afternoon, everyone. The court will call State of Wisconsin versus Darrell Brooks, case number 21 CF 1848. May I have the appearances, please?
Good afternoon, Judge Sue Opper, Leslie Basie, and Zach Wichow, appearing for the state of Wisconsin.
Good morning, Your Honor. My name is Darrell Brooks Jr. My name is Darrell Brooks Jr. Say my name. Darrell Brooks Jr. I'm in the say my name. Darrell Brooks Jr.
I like that part. All right, and we got another clip here coming in.
All right, good morning, everyone. The court will call State of Wisconsin versus Darrell Brooks, case number 21 CF 1848. Record should reflect that the state appears this morning by District Attorney Sue Opper, Deputy District Attorney Leslie Basie, Assistant District Attorney Zach Wichow, and the defendant Darrell Brooks appears in person in custody. I'd also like the record to reflect that he is appearing in jail attire today. He's also wearing a mask.
I object to that, Your Honor. I do not identify by that name and would like the opportunity to state that I'm here concerning this matter as third-party intervener in this matter, appearing as authorized representative for my client. I accept for value in return for value all the charging instruments in this matter and make my exemption available for discharge of all obligations and charges connected with this case. I do not dispute any of the facts in the charging instruments and would like to now reserve my rights, if I may.
Mr. Brooks, you just interrupted me within a minute of us starting this case here today. I'm asking you to respectfully not interrupt me. That's the second time, so I can go through the list of things that I need to get through this morning.
I just wanted it stated for the record that
Mr. Brooks, it wasn't the
you
proper
called me by.
time
That's
to
all.
do that. That's now the third interruption. So,
With all due respect, Your Honor,
Mr. Brooks, by saying all due respect doesn't change the fact that you're interrupting me. Your objection is noted, all right? But you need to stop interrupting me so I can get through what needs to be done.
But it is
I
my
have
right
a number
to-
of documents
it is
that I
my
need
right
to discuss
it
this
is my
morning.
right to-
Mr. Brooks, you do not have a right to interrupt the court.
No,
I will
that
remind
was
you
not
once
my
again
intention.
of the Supreme Court rule. It's on a yellow laminated, double-sided piece of paper that is before you. I
did not
checked, I
recognize
verified,
that.
it
I
is.
accept it in return for
Mr.
value,
Brooks, that's
Your
yet
Honor.
another interruption. Let me get through this, please.
Non-responsive answer is a tacit agreement, Your Honor. Can I have the originals for all my filings?
I'm not going to address that right now, sir. I don't have time, frankly, to look through everything that you filed to determine whether we've given you originals or not. In the future,
I
you need-
have the copies. I don't have the originals. Subject matter jurisdiction, Your Honor.
The court declines to address that.
Still has yet to be verified and proven for the record.
Your objection's noted.
So while we're on the record, may I challenge the subject matter jurisdiction?
No, you
of
may
the
not,
court?
sir. You need to file a motion in order to do that.
So
Mr.
the
Brooks?
motions I filed haven't even been responded to. I gave
Mr. Brooks, you're
3-day
interrupting me
No,
yet
you
again.
just weren't speaking,
All right,
so I didn't
Mr.
interrupt.
Brooks, you are now going to be removed to the
I
other
don't
courtroom.
consent to that.
I have
I'm
had
under
a
duress
dozen or
by
more
having
interruptions.
shock- I
We'll
have
be
shock-
off the record while we
shocks
do
on my
that.
ankle.
Thank you,
I don't
everyone.
agree to a stop. I move for a motion to dismiss for being under duress and being coerced into a contract that I did not consent or agree to. I do not. I have a right to be present for trial.
Coerced.
Let me know when you've had an opportunity to review it if you so choose.
I just stated for the record, I accept the value in return for value document.
All right, I'm going to move on,
I have
sir.
them here.
This is taking up valuable time with the jury. We need to keep going.
Is that a judicial determination, Your Honor, that I can't get an answer to
I
something?
don't believe there's any other preliminary issues we need to address unless preliminary other than the filing, sir, and other than the topics we've discussed this morning. I know you're holding up your objection sign, sir, but I am giving you the opportunity to come back over here. Would you like to come back to this courtroom? Record should reflect he's holding up his objection sign. It appears that he's writing, I don't know what, of course. Mr. Brooks, I'm going to ask you again. Would you like to come back to this courtroom for opening statements?
So I'm on the record.
You are. If you would please address my question.
So you want me to come back over there just to get brought back over here? Can the title man please direct the prosecutor to answer whether their assessment for the charges
Mr. Brooks,
in her possession?
no one's going to be answering these questions, okay? I'm not requiring the state to do that. I'm advising you to stop asking those questions. It will be considered an he's interrupted. Take him to the next courtroom. I'll make more findings when he is in the courtroom next door, and I can do that without an interruption.
Or agree to a estoppel, and I will move. It's even been put on record numerous times with inaccuracy. Even what happened today, nobody reported on record about me being bruised up and having to get bandaged up. How are you even a judge?
All right, you may step down, ma'am. Thank you.
How are you even a judge? Come on, man. This must be all about the 62Q trust, right? That you want to be the beneficiary of?
I'm going to give the jury their closing instruction. We are done with testimony for today. Please do not begin your deliberations and discussion of the case until all the evidence is presented. And I have instructed you on the law. Do not discuss this case among yourselves. The fourth count of the information in this case charges that Jarrell E. Brooks, on or about Sunday, November 21 of 2021, on Main Street in the city of Waukesha, Waukesha County, Wisconsin. Count of the information in this case charges that Jarrell E. Brooks, on or about Sunday, November 21 of 2021, on Main Street in the city of Waukesha, Waukesha County, Wisconsin, 939.50 sub 3 sub A and 939.63 sub 1 sub B of the Wisconsin statutes. The sixth count of the information, contrary to section 940.01 sub 1 sub A, 939.50 sub 3 sub A, and 939.63 sub 1 sub B of the Wisconsin statutes. The defendant has entered a plea of not guilty to each one of these charges of the victim named in that count. Cause means that the defendant's acts was a substantial factor in producing the death. 2, as to each count, the defendant acted and statements, if any, and from all the facts and circumstances in this case bearing upon intent. Intent should not be confused with motive. While proof of intent is necessary to a conviction, proof of motive is not. Motive refers to a person's reason. With that, I
don't agree to that, Your Honor, or consent to that.
Your lack of consent is noted.
And also for the record, I don't consent to the name that's being referred to.
I'll use this opportunity, sir, to ask what name you prefer to be called, because we now have evidence in the record where you provided your name to, upon questioning. There was video from when you were taken into custody, and then, of course, Detective Carpenter has testified about that as well. And we've been given no other name, sir, by which to call you by.
Do you see these boxes I got right here? Do you think I was able to go through everything in those boxes?
Mr. Brooks, I'm not gonna go through this with you again, where you attempt to put on the record all of these issues that you have when we're in the middle of a trial. Come in contact with the parties, lawyers, interpreters, or witnesses. Do not speak with them. The issues presented. Do not investigate this case on your own or visit the scene either in person or by any electronic means. Do not read any newspaper. Please rise for the jury.
And you even gonna call yourself a judge as much as bias you put up in here. Don't even tell the jury the truth. Got no integrity whatsoever. None. None.
Thank you, everyone. Please be seated. I would like an update on whether Mr. Brooks filled out a subpoena for Dawn Woods and provided that to the state. Has that been done?
No, we haven't received anything, Your Honor, and obviously, she can appear here voluntarily if Mr. Brooks wants to arrange that. I don't believe a subpoena is necessary. Our position would be, Your Honor, that we will not be responsible in any fashion for producing Miss Woods. Mr. Brooks talks to her on a daily basis. If he wants her here, he can produce her on Monday.
Yeah, they ain't gotta worry about that.
So I just wanted to know, because I know a subpoena form was filled out.
If
So
I want her to be here, she gonna be here.
I agree with
So
the
just
state
know
that
that.
she could certainly appear.
It ain't even gotta be no arrangement. All I gotta say is come. She gonna come. That simple.
Mr. Brooks, do you intend to call her as a witness? Because I'm directing you to
We
have her
said- we
here
said
at
all
9
that- We said
a.m.
all that at the beginning, man. Like, I don't even want to be in here that much longer. Just do what you got to do so I can get up out of here. I'm tired of being in the courtroom that has no integrity whatsoever. How can you even call yourself a
Mr.
judge?
Brooks, I need to make a record of some
I need to
things.
make a record too.
You don't
When
need
am
to-
I going to get the chance to do that?
All right, I need to make a record. He's being removed to the other courtroom. He is yelling at me. He's not going to let me make a statement or make the record that I need to make.
I'm finna
He
leave
hasn't
anyway,
sat
so what
down
do it matter?
for
You
the
can
better
hold me
part
in
of 2
contempt all
hours.
you want. You can hold me in contempt all you want.
I'm not
All
holding you
gotta
in
do is tell me
contempt.
if it's criminal or civil, so I can hit
All right,
you with you.
I need to
with
clear
what you
the
know is
courtroom because
coming.
I do need
I'ma
to
give
make.
you what you know is coming.
I need him to go to the
If
other
it's civil-
courtroom because I do need to put some
if
things
it's
on the
civil,
record. The record should
Where's the
reflect
contract between you and I?
that Mr. Brooks
If it's
is
criminal,
yelling at me.
what is the crime?
He is.
Who makes the claim? And what
He
is
is.
the...
I will make the record when we get back. I will step off, but Mr. Brooks, you're being
It ain't
taken
no,
to the
it
next
ain't no Mr.
courtroom.
Brooks. Don't try to address me
Thank
like
you.
that, like we cool. You don't have no integrity. How can you even call yourself a judge? Making tacit agreements, being biased, judicial misconduct, trying to steal somebody's system. It seems to me that all y'all been wanting to do is gang up. Be biased, be prejudiced, and gang up. 4 against 1.
I can't read your sign, Mr. Brooks. Can you hold it up closer?
Thank you, Mark, for gifting those memberships.
If it's a pledge that you will not interrupt me, I will bring you in for what will be the final section of my remarks today in the sentencing portion.
I think you should give him that opportunity before you
Go through the
I'll do that.
sentencing factors, and I can only read the top where it says objection, but
I can't tell what it is, what it says. He can bring the sign with. We'll clear the courtroom. We'll take a short break, and I will bring him back in. But I will warn you, Mr. Brooks, that there is one interruption. You will go back to that room because you will forfeit your right to be present for the sentencing portion. Record should reflect that it's 4:53. Mr. Brooks is back in this courtroom. Mr. Brooks, the only way I will honor that request is if you specifically waive your right to do so. Without that, that's not a convenience for you over there. It's you go over there when you frankly demand removal under Illinois versus Allen.
Demand anything.
No, your conduct did. So you
My
can
conduct
sit.
didn't demand anything either.
Right, Mr. Brooks,
You
please
keep
sit
changing-
down.
You keep changing
And I'm
the
going to continue
jurisdiction.
with my sentencing remarks.
You keep changing the jurisdiction. Jurisdiction is a subject matter jurisdiction that has yet to be proven on the record. in
Mr.
that court
Brooks?
and in this one.
Please sit down.
I would like to go back to the other court.
It's not a courtesy to you. If you'd like to specifically waive your right to be present, then I will entertain that. Otherwise, you need to sit down.
I never waived the right to not be present.
That's because you forfeited your right to be present by conduct. You're now back in this courtroom.
Your Honor, I did what you asked me to do.
You never once pledged to me, sir, that you would not interrupt. And you're demonstrating by being here that you continue to interrupt.
Man, I ain't trying to hear all that, because at the end of the day, I did what you asked me to do. You told the bailiff to tell me.
Mr. Brooks, this is not a debate.
You told the bailiff to tell me that I had to write.
It's not a debate. You asked to come over here, and I honored that,
Well,
and
I
I brought you
exercised my
back.
right 3 times. I shouldn't have had to do it 3 times.
None of those opportunities that you wrote to me said, I pledge to not interrupt.
I never had to do that before. You've never required that before.
That is actually...
You've never required that before. Every single time that I've been brought over there, after some time, sometimes very short, sometimes an extended period of time.
You are just simply trying to delay the inevitable. Please sit down.
I don't care about the inevitable. It was
I need
already
to
written
get
from day
through
one
this
what was going to
hearing.
happen. It doesn't make me lose any sleep about that. I know I'm okay. I'm okay with everything.
Then please sit down.
I just want to be treated fairly, which I have not been.
Please sit down.
And then Your Honor, and then you
Mr.
always make it seem
this is
like
not a
you always
debate.
make it seem like it's some type of aim, and it's not.
Please sit down.
We're talking about constitutional rights. You just told me, or you told the bailiff to tell me that I had to exercise a right that I should already have. I did that. Not once, not twice, 3 times. And it still wasn't honored. And then I raised this sign. I'm waving this for like 20 minutes, saying I would want to come back. I'm doing this.
You're here now.
Can I come back? Can I come back? Can I come back?
So sit down.
It wasn't honored. And then I said, okay,
finish.
I'll write this, and I'll see if Your Honor can see it on the screen. The objection sign saying, I've
Brooks,
exercised my right
if
to
you
be present.
stop for a
May I
minute,
have the order of the court?
I'll explain it, but you have to stop so I can explain it.
Your Honor, I did what you asked me to do.
Actually not.
Yes.
Let me explain if you would like.
If I didn't, Your Honor, if I did not do what you asked me to do, then why was I allowed to come back if I did not do what you asked me to do?
Because I'm frankly going to a very distinct portion of this hearing where I am going to impose sentence.
Okay, that doesn't answer the question, though.
Matters.
That doesn't answer the question.
Please sit down and I will explain and
Your
remain
Honor,
quiet without interrupting me.
With all due respect.
That doesn't mean you're respecting me, so please sit down.
With all due respect, you told the bailiff when I first said, because every time that I've been brought over there in the past,
Mr. Brooks,
you always stated,
I don't need a history
always
lesson of what
stated
I've done.
that when I exercise my right to be present,
Untrue.
You've always said,
Untrue.
we have the record. We have the record. We can dig into the record.
Mr. Brooks?
I know what the requirement was of me going over there. You've always stated on the record that when I exercise my right to be present, you will bring me back if I will follow the rules of decorum. That's your exact words, which you said every time.
Which you're demonstrating right now that you have absolutely
Your
no
Honor,
ability to do.
With all due respect, I've never had to go through any type of certain words that needed to be said or stressed or anything like that before. I've always done it the way that you've asked me to do it. No different than today when I told the bailiff I would like to be present. You told the bailiff if he wants to be present, he has to put it in writing.
And pledge to me that he will not interrupt me.
I put it in writing.
Without a pledge.
So why am I here?
Because I'm going to move on to another phase of this hearing, and I thought it important that you be here in person.
So I was here.
But you didn't reclaim your right to be back here.
Then why am I here then, Your Honor?
Allowing it to
happen.
Okay,
and I respect that you're allowing it, but still, it doesn't answer the question, though, Your Honor. It does not answer the question.
Mr. Brooks.
Your Honor, as a public servant, I have the right to ask questions of Your Honor.
I'm going to ask you one more time, and if you refuse to sit down, then you are in direct disobedience of a court order. Sit down
and be quiet so I can make the appropriate record.
Can you tell me what the court
Right,
order
he's
is?
not going to obey. He's now forfeited
I
his
didn't say
right
I
to be
wasn't gonna
present.
obey.
He will go into the
I
other
didn't say I
courtroom.
wasn't going to obey.
We'll be
I
in
just
recess
asked what is the
until he's
order.
there.
I just asked what is the order. I didn't say.
It's not about me trying to interrupt you, Your Honor.
Mr.
All I'm
Brooks,
saying is,
I'm going to address the next one,
what
so
you-
please pay
what you
attention.
were saying about decorum, I was asking, does that fall under the First Amendment? Because the First Amendment, which is my constitutional right, says that I have the right to freedom of speech and to be heard in this court.
Mr.
That's all I'm
Brooks,
merely-
again, you have the right to present a defense, but that right is not unfettered.
But that's under
That
the Sixth
right,
Amendment. I'm
Mr.
talking
Brooks,
about the First
you
Amendment.
are interrupting me. Stop.
Because you're talking about
No, because you're
talking about an
purposely
amendment that I'm
doing
not
this,
referring
so
to,
I
Your Honor.
can't get my reasoning
But
out.
I'm
You
not
make it
referring to the
incredibly
Sixth
difficult.
Amendment. I'm not referring to the Sixth Amendment.
Mr.
I'm referring
Brooks.
to the First Amendment, which clearly says that I have the right to freedom of speech and to be heard in the courtroom. Are you not going to honor my constitutional right, Your Honor? If not, that is judicial misconduct, and you're making a judicial determination to not honor my constitutional right. I just want to be treated fairly, like anyone else, which you said on the record that you will be fair and impartial. What
Mr.
you're
Brooks,
doing
you
is
also
not
have
fair
an
and impartial.
obligation to treat this court fairly, and you have an obligation to follow the rules of courtesy and decorum, the rules of procedure, the rules of evidence.
Your Honor, I did
That's
not-
the playing field that you willingly entered into and made a deliberate
did not.
decision to waive your right to an attorney
I
and
cons-
to appear
I
in this
consented-
case as your own
I consented
attorney.
to represent myself pro per. The same paperwork that you gave me, you have, and I also have a copy of the same one where I scratched out what I did not agree or consent to. We both know that, Your Honor.
Mr. Brooks, I made findings regarding that, and those findings stand. That despite you scratching out some of those words on there, I made very specific findings about your waiver of right to an attorney. So we're not going to relitigate that here right
You also
now.
accepted the terms of the paperwork that I
Mr.
filed out.
Brooks, I'm not going to engage with you about whether you and I have entered into some type of a contract.
We did not.
Or engage in
We did
any
not.
type of
We
that
did not
kind of
enter into
dialogue.
any
Because
contract.
that's what you're claiming through some
No,
of these
I'm not.
filings,
I'm
and
not
you've
claiming
said that previously.
I am not claiming that, Your Honor.
So,
In any way,
Mr.
shape, or
Brooks,
form,
I am
do not
giving you
consent to
some
any
leeway.
contract.
You continue to talk over me. It's, you please, I'm asking you to follow the rules of civility. Simple rules, sir. Don't interrupt me.
Did I not just let you read the whole jury instructions and follow the rules that you said I have to write down?
You did.
Anything that I object to and then hand it in.
Except now that we're discussing them, it seems to me that the rules don't quite matter to you, sir.
No, that is not what's
So,
being asserted
here's
on my
what's
end.
happening, sir.
All
I'm telling you,
all
I'm
I'm asking
advising
for-
you to respect the rules. I'm advising you that if you continue to interrupt, you risk forfeiting your right to be present in this courtroom.
Are you?
Because I still need to continue with these proceedings, sir. I need to go through all of the documents that you filed, and you're not letting me do that.
Because we didn't
So
get
I'm
past
gonna,
the
if I
issue.
need to, I'll remove you to the other courtroom so that I can do this. And yes, exercise the mute button, sir. And
This
then
is
I'll bring
something
you
that was
back on
filed,
the
though.
jury's back.
This was filed, though, Your Honor, and it's a valid.
Mr. Brooks is
it's valid.
clearly not following the simple rule of civility that I have established.
That's
He
inaccurate,
continues
Your
to
Honor.
interrupt. He's not providing this court with
inaccurate, Your
ability to make rulings on the record without interruption. So this is your final warning, or you will be removed to the other courtroom.
Will Your Honor honor my First Amendment right?
I'm
Or
not
are you
answering
making
that
it- or are
question,
you
sir,
making
because
it-
I've already addressed
So
it.
you're making a judicial determination to deprive me of my constitutional
I am not
right.
making any such determination,
So
sir.
you just said you're not going to answer the question about my First Amendment right, which says
Sir,
that
I've
I have
already
freedom of
answered the
speech.
question that you have a right to present a defense.
That is the
You have
Sixth
a right
Amendment,
to
not
be
the First.
present.
You're trying to twist
You
up the
have
amendments.
a right to present your defense, but your rights are not unfettered.
Yes, they
Your
are,
rights.
Your Honor. You're citing the Sixth Amendment which I am not
Mr. Brooks,
questioning.
your First Amendment in some respects is circumscribed by the rules of evidence and the rules of procedure.
Does it say that I have
So it doesn't
freedom of
mean you
speech?
get to say anything that you want in
No,
front of a
I'm-
jury.
Your
And
Honor.
it doesn't mean you get to put forth any kind of evidence that you want
Your
in front
Honor,
of a
am
jury.
I
What
being-
it means, sir,
am I
is
being
that you
disrespectful?
must
Am I
follow.
calling you
Yes,
out your
you're being
name? Am I threatening
disrespectful because
anybody?
you're
I'm
not.
not doing anything of the sort.
All right, he is continuously talking over me. So at this point, I'm going to find that he's forfeited his right to be
I have
present
not
as I
forfeited
go
my right,
through
Your Honor. I have
his
not consented to any. I'm
his
simply trying to
paperwork. He's to be
understand
removed to the other courtroom
I'm
until
simply
such
trying to
time as he
understand
can pledge to
why we're
follow
not
the
talking
rules
about
of
the First
decorum and
Amendment. I'm not
civility.
talking about the
We'll be
Sixth
in
Amendment.
recess until we have
Your
everything
Honor, I do
set
not
up.
agree to an
The record to
estoppel.
reflect, I'm stepping off. Based upon Erica Patterson's testimony, who, by the way, she showed grace and dignity facing you, the man who clearly has no regard for her as a mother of one of your children, as someone you had a domestic partnership with and a relationship with at one point.
That's not true.
We know, and I would say this goes to your character, what was shown through that altercation and going up the hill, following her, slapping her. You know, the rules don't matter to you, not the rules of the road, not the rules established by court orders, not the rules even of decorum and decency. And I'll get to this more fully when I talk about your character. We know that on November 20th, and she was very contrite about this. She told you where she was. She invited you out there. And that you had contact with her on the 20th. There was some physical.
Contact with her on the 20th.
Mr. Brooks, this is my time. You need to not
That's
interrupt.
the reason why the charge was dropped.
Mr. Brooks,
The state
you need to stop.
said specifically, wrote you, Your Honor, and said that they know it was no incident that day.
Mr.
And now
Brooks,
you want to sit up here.
do not interrupt
now
me
you-
or you will be removed to the other
and now you
courtroom.
want to sit up here
Stop.
and try to
now.
add something in that you know for a fact never even happened. You want to sit up here
Mr.
and talk
Brooks,
about
every
who has
time-
grace and all this. You talking about someone with 5 kids that don't have custody.
You need to
of
stop
none of
right
them.
now or you will be removed.
Remove me then.
All right? He will be removed. He cannot simply stay
I don't
quiet when
consent
this
to being
court talks.
sentenced anyway. I don't consent to this. Just like I told you, I don't know the.
We'll be in recess until he's
I don't
removed
even
to the other
understand
courtroom.
the true nature and cause.
Mr. Brooks, my question to you is, do you have any position on the state's proposed jury instruction? Otherwise, I'm going to rule on their request.
You're gonna rule on the request anyway. I got a lot of questions that don't get answered.
I have to rule on the request, sir. It's been a proposal filed with the court.
You haven't ruled on subject matter jurisdiction yet.
Yes, I have.
No, you
In
haven't.
any event, do you have a position on the jury view, sir?
Yeah, what about subject matter jurisdiction?
One last time, Mr. Brooks, do you have a position on
Can
the
I
state's
go over the
proposed-
document, please? Can I do that, Your Honor?
sorry?
Respectfully for the record, may I do that? You seem like the same thing that was there yesterday.
It's not. There are some changes.
What changes?
Reference
It's
to
the same.
the-
It's the same document that was
Reference to
accepted for value and
the-
returned for value yesterday. The same document.
It's not the same. The changes were put on the record verbally by the state. It's taking out reference to Sallyport of the Waukesha County Jail. Now, you also mentioned previously, when I referenced going back to your cell to get the list, I'm giving you that opportunity. You asked me to do that.
I did not ask you to do that. The question was, where was the list at?
That's true. So you said the list was in your cell. I'm advising you that I'll give you the opportunity
I
to
don't
go.
want to do that.
Can I finish? I'm advising you that you are being given the opportunity, if you so choose, to go back to your cell to obtain the list of witnesses that you have been working on. Further advising you that if you choose not to do that, your one option would be to verbally tell the court any additional names to what you've already provided.
write those down for the court, so that either tell me now or write them down so that I can include them in the list of names I'm providing to the jurors.
So how am I supposed to do that without the list in front of me?
The list that you have in your cell?
How am I supposed to do that without the
I'm
list?
telling you, I'm giving you the opportunity to go get that.
I'm not
So,
gonna go do that.
Mr. Brooks, I'm not gonna play games with you.
And
I'm giving you
I'm
an
not gonna-
opportunity.
And I told you that I'm
either
not
go to
gonna
your
do that.
cell and
You
get
said
the
I have the
list or
opportunity
not.
to do that.
All
You
right.
said I have the opportunity.
I'm not gonna
going to do
demand that you do it, but you have to understand, sir, that if you
I
choose
don't
not to
understand.
do
I
that.
don't understand. I don't understand.
All right,
I've
Mr.
made
Brooks.
that clear. I don't
You
know how
claim
many
to not
times for the
understand,
record.
and that's been made very
No,
clear
I don't
here, sir.
understand. You're not
So-
gonna get me to consent to something that I don't consent to or agree to. I do
know.
not
All right.
understand. Just
Mr.
like I
Brooks,
don't
we're gonna
understand
take
the
a
nature and
recess
cause
so
of
that the court can get this
exactly
information
like I've
from
been
the
telling
state.
you from the beginning.
Okay, he's continuing with his disruptive behavior. It is his choice to do that. Mr. Brooks, you are hereby warned, once again, if you continue with that, you will be removed from the courtroom.
Remove me. Remove me.
Requesting to go to the other
Remove
courtroom?
me. I told you that before I even came over here.
Sir, are you requesting to
I
go?
told you that before I even came over here.
Mr. Brooks, are you
That
requesting?
it was pointless of me to come over here. You can smile all you want and think
Sir,
it's funny. I don't take this as a
preference-
joke. I don't take this as a game.
My preference is for you to be
You
here.
expect me to answer all these questions that you have for me, Your Honor, but you have yet to answer one question that I've asked you. You have yet to
Right.
verify anything
You
by
can take
sworn
him back to
affidavit.
the other room.
You
He's
haven't
been
even honored-
disruptive.
You haven't even honored my request to make an offer for my appeal.
Thank you, ladies
You
and
haven't even
gentlemen. We'll
honored-
have to,
you haven't even
clear
done
the
that.
courtroom.
I don't agree to a stop and I move this court for.
We do have two witnesses here ready to go. If the next witness goes relatively smoothly, would you consider letting us call the second one and maybe wrapping up by about 6 o'clock?
Yes.
Okay, thank you. If not, he can come back tomorrow, but he's been here twice already.
No, we'll keep going. I prepped the jury for that yesterday, so we're good. I'm gonna have the jury brought out. All right. Bring the jury in, Madam Clerk.
And I object to that.
To the timing?
Yes.
Your objection's noted. We're gonna make up for lost time from yesterday.
So can we adjust the subject matter jurisdiction?
No, we cannot.
Talk about that? We're not gonna address that either. That's still not gonna be proven, right? It is frivolous stuff. That's gonna get pressed every time, so. I've yet to prove subject matter jurisdiction, any jurisdiction at all, right?
The jury will disregard the comments being made by Mr. Brooks at this time. They are a mischaracterization of the law.
Absolutely not. They are absolutely not. Are you aware of who the plaintiff is in this matter?
Objection relevance.
Grounds?
Mr. Brooks, not now.
Not allowed to.
Not now. The jury is in this courtroom, and you will show respect for them and for this court.
Respect for them would be
Mr. Brooks.
telling them the truth.
Stop. I'm putting you on notice that you are on the verge of this court creating a curative instruction about your frivolous arguments. I will not have you claim legitimacy for what are debunked, frivolous, sovereign arguments.
Then
That is
prove
why
it.
your questions
Prove it.
are being
Prove that it's
objected to,
frivolous. Prove
and
that it's
why
frivolous. Prove it.
all the cases that we've already referenced, sir. We are in recess. We'll be back
And
in
prove
5
it.
minutes. Thank you, everyone.
I don't agree to a estoppel. Can you prove?
The favorite part when he's muted.
Your objection's noted. We're gonna make up for lost time from yesterday.
So can we adjust the subject matter jurisdiction?
No,
in
we
this
cannot.
matter? Talk about that? We're not gonna address that either. That's still not gonna be proven, right? It is frivolous stuff. That's gonna get pressed every time, so.
didn't realize I did that part twice.
Any jurisdiction at all, right?
The jury will disregard the comments being made by Mr. Brooks at this time. They are a mischaracterization of the law.
Absolutely not. They are absolutely not. I don't understand the jury instructions. I don't understand anything that's in these proceedings, and I'm not going to participate in something that I don't.
Provided you yesterday as a courtesy with a copy of my oaths of office. My name is on that as well.
They were not certified.
You are attempting to disrupt with asking questions like this.
I'm here concerning this matter as third-party intervener.
I don't know if the mics are on.
It should be, yes.
Okay. I'm soft-spoken, I'm sorry.
Said no one ever.
Well,
that was all loud, sorry.
So,
Nobody reported on record about me being bruised up and having to get bandaged up. Was not. And I would like the record to reflect that you have not shown verified proof of subject matter jurisdiction whatsoever. And that by refusing to answer, that is a tacit agreement by you, Your Honor, which you understand what that means. I know you do. Can I go back in the other courtroom? Because I'm not going to do this with you. I'm not.
You interrupt, you don't wait for anyone to finish.
I don't consent to being called by the name that this court chooses to identify me by. I want to state for the record that I'm here as a third-party intervener on special appearance on behalf of my client. Can that be noted for the record?
It was noted this morning.
May it be noted again for the record so that we can keep the record clear and accurate.
I'll make a finding that he's forfeiting his right to be present in this
I didn't forfeit
courtroom.
anything. I asked.
The court will let the jury know that when they come
So
in.
are
Yes.
you overruling the fact that the true nature and cause has not been presented to me? That I don't know what the true nature and cause of the charges are? Should I abstain, Your Honor?
Next question.
So I can't get no grounds. Okay.
That's a new song.
I'm
I
not
can't get
making
no
a
ground.
voluntary waivery of anything.
So there'd been the subpoena sheet that would have had, your name and, a number of different.
What do you mean my name? What are you referring to?
I believe it would have said Daryl Brooks on it.
Are you aware that I don't identify by that name?
Objection, argument.
Sustained.
Sorry.
They laughed
Are you willing to
at him.
expressly waive that right on the record right now?
I'm not going to expressively waive anything. I'm seeking to merely understand.
Sir, I cannot give you legal advice. I cannot give you the understanding that you want.
I need to make an appropriate record.
I just told you that I don't understand the questions you're asking. What do you want me to do? You seem like the same thing that was there yesterday.
It's not. There are some changes.
What changes?
Reference
It's
to
the same. It's the same document. That was
Reference to
accepted for value,
the-
returned for value yesterday. The same document. Now, please go back into the other courtroom. Not allowed to.
Not now. The jury is in this courtroom and you will show respect for them and for this court. Sorry, was there an objection?
Yes.
The basis of the objection?
Relevancy.
It is relevant. It is received, 51B.
Objection be noted for the record, Your Honor.
It already has been.
I can't answer something I don't understand.
I believe you're choosing not to answer them,
You can
sir.
believe what you want to believe. I believe that you hiding stuff from the jury. I believe you haven't been impartial or fair. You haven't let me even enter anything into evidence, which is my right to do so. I want to
Stop interrupting me.
You were quiet. I didn't.
Mr. Brooks,
Respect for them would be
Mr. Brooks.
telling them the truth.
Stop. All right. Well, bring the jury in, Madam Clerk.
And I object to that.
To the timing?
Yes. It is my right to do so or to not do so.
If I have you stay in this courtroom, are you willing to follow the rules of decorum and courtesy?
I do not understand the question you are asking. It is frivolous, though. That's gonna get pressed every time, so. I have yet to prove subject matter jurisdiction, any jurisdiction at all, right?
The jury will disregard the comments being made by Mr. Brooks at this time. They are a mischaracterization of the law.
Absolutely not. They are absolutely not. I don't understand.
All right? You willingly waived your right to an attorney. I made all of those findings, so we will go
You
forward.
made those findings,
I
but
am
they-
not obligated to answer questions.
You made
When you
those
ask me
filings.
questions, I'm going to mute him.
So while we're on the record, may I challenge the subject matter jurisdiction?
No, you may not, sir. You need to file a motion in order to do that.
So is that a judicial determination that you're making?
My decision on the record stands, sir.
And
Mr. Brooks, you do not have a right to interrupt the court.
I always thought of Newton as gravity, so that was a bit of new information. I'd like to go back over there, Your Honor.
So my question to you is, do you want to come back to this courtroom, sir?
So I can get sent back over here, because as soon as I say something, I'm gonna get sent out. Do you see these boxes I got right here? Do you think I was able to go through everything in those boxes?
Mr. Brooks, I'm not going to go through this with you again, where you attempt to put on the record all of these issues that you have when we're in the middle of a trial.
You can't force me to stay somewhere that I'm making a request not to.
I cannot explain court procedures or the law to you. So with that, Mr. Brooks, that's another interruption. You keep going. Stop.
Not an attack. It was not planned, plotted.
Bring the jury in, Madam Clerk.
And I object to that.
To the timing?
Yes. This was not an intentional act. Quote unquote jury view. So you want me to come back over there just to get brought back over here? I just stated for the record, I accept for value in return for value document.
Mr. Brooks, you just interrupted me within a minute of us starting this case here today.
I'm still trying to understand the whole process. I just want for the
You
record.
will have an opportunity when I give you an opportunity. No one else is speaking at the moment but me. You need to stop interrupting.
I don't identify by that name.
I believe we are using the accurate name.
did
I
not
checked, I
recognize
verified,
that.
it
I
is.
accept it in return for
Mr.
value.
Brooks, that's yet another interruption.
Non-responsive answer is attack and agreement, Your Honor.
Jury's coming out.
Can I at least raise the issue of subject matter jurisdiction?
No, there's no lawful motion before the court. You may not.
Audio
I don't
means to
consent
participate.
being removed from the courtroom, Your Honor.
That's another
And you
interruption.
haven't shown me any lawful case law that I from the court
Mr. Brooks?
proceedings in a trial and forced under coercion and duress to appear in the trial that I am needed, that I've tried to express. No, like the record to reflect, I still haven't received my original copies of my filings here this morning with the timestamp. With all due respect, I do not agree with that assessment whatsoever.
Do you have a position on the jury view, sir?
Yeah, what about subject matter jurisdiction?
Mr. Brooks, did you hear the question that I asked you?
And I respectfully keep the position that I just put on the record. Motions I filed haven't even been responded to. I gave
Mr. Brooks, you're interrupting me yet again.
You just weren't speaking,
All right,
so I didn't
Mr.
interrupt.
Brooks, you are now going to be removed to the other
don't
courtroom.
consent to that.
I have
I am
had
under
a
duress
dozen or
by
more
having
interruptions.
shock- I
We'll
have
be
shock-
off the record while we
shocks
do
on my
that.
ankle.
Thank you,
I don't
everyone.
agree to a stop. I move for a motion to dismiss for being under duress and being coerced into a contract that I did not consent or agree to. I don't consent to being called that name, Your Honor,
I understand,
for
sir.
the record.
And I have advised you previously that I will continue to refer to you at times by that name, as I believe it's appropriate given the charging instruments in this case.
Was my ICF obtained by clerk of courts?
The one requesting the copies of various documents?
The one asking for the complaints?
Yes, my understanding is they're working on it.
Just wanted that clear for the record.
I do need to.
Your Honor, or consent to that.
Your lack of consent is noted. And the jury will be brought out and you'll be asked to call your next witness.
Being called that name.
So noted.
And we still need to address subject matter jurisdiction before the jury's brought out.
I will not be doing that.
Will it be proven for the record?
The record stands.
So is that a tacit agreement that you don't have to answer that question, Your Honor?
I make no such agreements with you, sir.
So that means you can answer a question then. Will we be addressing subject matter jurisdiction on the record, and will it be verified and proven? That's gonna get pressed every time, so. I've yet to prove subject matter jurisdiction, any jurisdiction at all, right?
The jury will disregard the comments being made by Mr. Brooks at this time. They are a mischaracterization of the law.
Absolutely not. They are absolutely not. They are.
All right, thank you, everyone. Please be seated. The state may call its next witness.
The state would call.
Understands that a lawyer may be
Formed,
appointed if the
I never
defendant
said I
is
understand.
indigent and understands the disadvantages of
Never once said I
self-representation.
understand.
He is voluntarily and freely waiving the
As a
right
matter
to
of
be
fact, I do not
represented by
understand.
counsel and is making a deliberate choice to proceed without counsel. And therefore, the court will grant the motion to withdraw brought by Attorney Perry and Attorney Keyes. And from this point forward, Mr. Brooks will proceed as his own attorney.
I don't understand what is going on.
I believe you do. Please sit down. The jury's coming in.
What do you mean by complaint?
The complaint would be a reference to the charges in this matter.
Are you willing to not interrupt the proceedings with disruptive behavior?
I do not understand the questions that you are asking. I'm trying to seek to understand how the testimony evidence that was given could be
Mr.
considered
Brooks, I've already
evidence.
dealt with that. I'm not going to deal with it. If
Your
Madam
Honor,
Clerk, have the jurors brought
Your
in,
Honor,
please.
what you're doing is judicial misconduct. You're making the judicial determination, and I'm not allowed to ask questions. Again, as I've stated numerous times now for the record, I will not answer or comply with anything I do not understand.
Well, given that he won't answer the questions directly, for now, he is to remain in this courtroom.
I'm requesting to not be in this courtroom.
But you won't answer my questions regarding that, sir.
I did. I told you I don't understand. I've merely brought up subject matter jurisdiction because it has merit. I've merely tried to seek to understand the proceedings that I do not understand. You're rushing me to judgment by constantly removing me from the court when I should be present for all proceedings and I should be able to understand, which I do not.
That's not answering the question, sir.
You asked me a question, I answered it. I don't understand. How can I answer something that I do not understand, Your Honor? Once again, I do not understand the charges, the nature of the charges against me. I do not understand why Your Honor will not answer mere questions that would give me clarification on understanding. I'm not attempting purposely to be disruptive, disrespectful in any manner. But if I don't understand something, it benefits me to ask so that I can have clarity. You always state that. You always state that.
To sit down and to pay respect to this court, to these jurors, to the process.
It is my right to stand or to sit, Your Honor.
All right, let me start with the jury instruction.
You'll
There
start
is
with,
one I
you'll
would
start
like
with subject
to.
matter jurisdiction? I'm seeking to understand, Your Honor.
Mr. Brooks, final warning.
I'm seeking to understand, Your Honor.
In addition, sir, parties are able to file requests with the court. It's called a motion.
But it doesn't matter what we believe, Your Honor. I'm merely stating a request to not be present for these proceedings. I cannot answer the
Sir,
questions you are asking me because I don't understand them.
You understand your right to be present in the courtroom. Are you telling me you
I don't understand
that right?
anything. Nope, I don't understand. Nope. Will my First Amendment right, which is freedom of speech.
That's, Mr. Brooks, I cannot explain to you if you don't understand the basis in law for the denial.
You're right, I don't understand. But
So,
I was
but that
following-
doesn't mean we're going to have a
I was
discussion
following- no,
or a
I'm not
debate
trying to debate
about
with you,
what
but I
it
was
means, because we're
following-
not
I
going
was
to do
following
that.
the rules that you said.
So, the bottom
by
line is, I
writing
don't
and
feel,
sending-
Mr. Brooks, stop talking.
Issues.
When I asked you where you hold
Are
me in
you
contempt,
going
you
to
said civil.
respect the decisions that I've made
They're
by
not
not interrupting
they're
me?
not correct decisions, Your Honor. It's kind of funny that they disappeared. No,
That's
ICF
a
disappeared
fact,
before.
Not an evidence, sir. So
They haven't disappeared before. I've always got copies. What's the difference now? Her why you were getting them before?
My understanding is they were forwarded to me, sir. But
So what happened to this one being forwarded to you?
sir, I can't answer that. I can't answer what I don't know. So
It
the
seems
jury's
like you're
coming
trying
in.
to
We're
avoid
going to
it.
keep.
That's
We're
what
going
it
to
seems
continue
like.
with the trial. No, I've declined that already, sir. I'm not going to address
Under
that
what
further.
law? Under what lawful law? Did you get a license plate number of the vehicle?
Your 90611. Move on to a new topic, please. I understand that.
I can't answer. You asked me questions. You asked me questions. I didn't answer them based on my understanding. How can you force me to understand what you're asking me if I don't? And then you still make a finding based on that. How is that lawful law?
Mr. Brooks, I stand behind the record that I've made today.
And that's fine. I'm not
advising you
arguing
that
with
if
you
you
about what you
continue
rude.
to talk
I'm saying,
over
how
me,
can you do that without my
If
consent?
you continue to raise issues that I've
That's
already
a violation
addressed,
of my civil rights.
if you continue to raise these issues, sir, and thwart the purpose of this court, which is to finalize the jury instruction and the verdict forms, you will forfeit your right to be present in the courtroom, and you will appear from the other courtroom.
So is that a judicial determination that you're making?
My decision on the record stands, sir.
And I would like the record to reflect that you have not shown verified proof of subject matter jurisdiction whatsoever. And that by refusing to answer, that is a tacit agreement by you, Your Honor, which you understand what that means. I know you do. I don't consent to being called by the name that this court chooses to identify me by. I want to state for the record that I'm here as a third-party intervener on special appearance on behalf of my client. Can that be noted for the record?
It was noted this morning.
May it be noted again for the record so that we can keep the record clear and accurate. Was my ICF obtained by clerk of courts?
The one requesting the copies of various documents?
The one asking for the complaints.
Yes, my understanding is they're working on it.
Just wanted that clear for the record. I always thought of Newton as gravity, so that was a bit of new information.
On the record and
Obviously, I don't know if the mics are on.
it should be, yes.
Okay. I'm soft-spoken, I'm sorry.
Said no one ever.
Um,
Oh, that was all loud, sorry.
So,
Let the jury know that when they come in.
Are
Yes.
you overruling the fact that the true nature and causes not been presented to me that I don't know what the true nature and cause of the charges are. Grounds for the sustain, Your Honor.
Next question.
Okay, I got another one. Hang on, guys. And I apologize that some of these are repeating. I did not realize how many times I had some of these on here. But this next one I know has some stuff, so hang on. And I'm sorry that I'm taking so long to get this set up, but it was downloading while we were watching the others. So there it is.
The right moves. And as Winnie Dorch found out, the only requirement for membership is to be a grandmother.
If it's one thing these women have in common, it's for sure rhythm. And just like the song, We Are Family, they got all their sisters with them.
We all truly, I think, love each other too. We're like sisters.
Meet the Milwaukee Dancing Grannies.
Just take those old
Leanne was so cute.
Don't let the title fool you. They can move, groove, and maybe even outbeat you on the dance floor. Just ask Lee Owen.
Can you keep up, Lee? Can you keep up with the group?
Oh, you bet I can. Yeah. I'm encouraging them. Come on, come on.
An award-winning dance troupe. The squad performs in holiday parades like 4th of July and St. Patrick's Day, showing off what these senior citizens can do. Janice Kramer says the support from the crowds gets them going.
Who doesn't like to hear wolf whistles at this age? I mean, come on, really? And everybody's hooting and hollering and cheering you on.
When we would do like past the veterans, and we do our kicks and, do some kind of sexy hip thing.
The gentlemen at the VA love this step.
It's amazing.
They're even well known outside of Milwaukee County, little kids spotting them from a distance.
And another time, a bunch of us had gone up to Door County, and we were at some historic place, and there were some kids there waiting for a bus. And we had our Dancing Granny shirts on, and this one girl goes, "You're Dancing Grannies?" And a whole bunch of them got up and came over and started talking to us. And it's like, oh, kind of like minor celebrities.
But let's rewind back to 1984, the group's humble birth.
And it was a jazzercise group. And the women wanted a little more, so somehow they got into this. And the first parade that was ever done was South Shore Frolic.
Things have changed over the years. New women coming and others retiring. They've held their own and the crown.
1 and 2 and 3 and 4.
Even incorporating a choreographer.
7 and 8.
Jenny Swanson.
10 and 11.
A blessing to the team for 19 years, whipping them into tip-top shape.
Pony!
She's like the heart and soul, honest to God. She keeps us on our toes.
I want it from the hip and I want it to matter. I love dancing, and now that I can't with my surgery, it's like I lost a best friend. But the Dancing Grannies had a place for me here, choreography, and being an instructor. That's a really important part of my life, especially now where I can't dance. And I love it, and I love the ladies, and they're my family. They're my friends. Always smiling, right?
The Grannies practicing once a week at Wilson Park. Information, lines must be perfect, shoulders up, and watch your partner.
Stay with your partner. Look at your partner.
President Tamara Rosentreader says the ladies are so passionate they're running through the drill after hours.
We each individually practice, at home to make sure that we have the routines down.
You did really good.
The sisterhood doesn't end when they leave practice. It actually becomes stronger.
We do go out to special dinners a couple times a year. We just had a huge formal. Like we have this trip that we go on, which is out in Minnesota. There's a parade out there that we do, and everybody carpools together, and it's a good time.
It's just nice to get to know, the different grannies. It's nice to get to know their families. And when one does retire or quits or whatever, it's not only them, it's their family that goes. A lot of the husbands help in the parades, and so you miss them too.
You're all in sync. I told you, just like the Rockettes, you'll do it.
Dance is just a piece of the puzzle that blends the Granny gang. Staying healthy sits at the top of their list.
It's a good workout.
So it's great exercise, you know, and I think it keeps us young.
Where's the funky stuff?
While they may be stars, they're
so cute.
There you go. We like to reach out to the communities and the societies of what needs help. And whatever we can do out there, we will do.
Because they're thankful for the support given to them. So if you ever see the dancing grannies,
Time's up.
Never hesitate to say hello or ask about membership. You will be loved unconditionally.
Thank you, ladies. These rules are intended to assure that jurors remain impartial throughout the trial. If any juror has reason to believe that another juror has violated these rules, you should report that to me. If jurors do not comply with these rules, it could result in a new trial involving additional time and significant expense to the parties and the taxpayers. You are to decide the case solely on the evidence offered and received at trial. With that, you are excused for the evening. All rise for the jury, please.
It's weird how he gets an evil face right here all of a sudden. Look at
I
his
just have a
eyes.
couple of housekeeping matters. Please be seated.
It's out of nowhere.
My recollection, there's been a couple of exhibits that were annotated and captured so that it's notated on the record. And so there's a cover letter, and then there's some documents pursuant to your request. I'll give that to and then along with, on the back, will be that incident report. So that's being provided as well. And then the state, you'll get a copy of that incident. Then, just, Mr. Brooks, those things were provided to you?
Yeah, I set the value, return for value these filings, and just very briefly so we can get out of here. I have to raise this issue.
What issue is
My understanding, how can someone who's not an injured party testify on behalf of somebody who is an injured party?
Mr. Brooks,
and it still be
I'm
charged?
not addressing this. It is a frivolous argument. You have a misunderstanding of the law. We are in recess. I am leaving the bench. Thank you,
Okay.
everyone. We're in recess.
So that's a tacit agreement. We're not.
I think
What will
that's
the
fair,
motion
Your
be?
Honor. It's a motion to conform the information to fit the evidence.
Oh, all right. I'll take that up.
We'll have it in writing for Mr. Brooks in the morning, Your Honor.
Okay, that'll be great. All right. Anything else from you, sir?
No, I redid the. It's not the exact order that I'm gonna call the witnesses, but it's pretty much
Who you want, like each time block, morning or afternoon?
exactly.
You'll be ready to
It's
go
just
tomorrow?
not an exact order like I'm gonna call this person.
I'm
this
not gonna hold you to
person.
that, as long
Yeah.
as it's by time blocks, if you wanna call it that, but be ready to
Well,
call
I did
witnesses.
it just so I can state for the record, so it'd be easy to follow. I did the names by threes. I'm guessing the first three would be the morning, the next three would be the evening.
I'm
and
so
then
glad he
Friday,
explains how he did it.
3 morning, and then 3 evening. Is that fair?
It was so hard to follow.
I think so.
Yes, we may be able to move faster, but we will attempt to stay in contact with the witnesses if we can, bring somebody here sooner. If the court's got time, we'll do that, but that's very reasonable.
And then do you have any idea how long you anticipate your opening will be?
Opening statement?
Yes.
I don't think it's any way to gauge how long it will be.
Just be mindful, sir, it's not the time to make argument, opening statements, as I like to call them, and what the jury instruction references, it's the roadmap. So I will expect to hear a lot of the evidence will.
I love that part where they make fun of him. Let's watch it again.
Any way to gauge how long it would be?
Just be mindful, sir, it's not the time to make argument, opening statements, as I like to call them, and what the jury instruction references, it's the roadmap. So I will expect to hear a lot of the evidence will show, the testimony, things of that nature. If it turns into argument, that's what happens at the close of the case.
What do you mean by argument?
If you're trying to argue the evidence and what it means.
No, I'm not trying to argue.
But this will be what, basically to lay out what the defense, what I would expect is for you to lay out what the defense or defenses that you believe you'll be presenting evidence about will be. To kind of, again, give the jury a roadmap, an idea of what to expect as your witnesses come forward.
And Your Honor, just one other quick thing. I know that you asked the defendant if he had any questions that he wanted you to ask. I would just, the issue that he's brought up with being deaf in one ear, I'd also ask if he has any questions of yesterday's panel that maybe he's unclear or didn't hear anything, although he didn't notify anyone he was having trouble hearing. He was answering questions in the other room without the headphones on. Actually, he was given the headphones. It took him a minute before he even thought to put them on. But just to see also if he has any questions, obviously he's got to follow the Supreme Court rules, but if he wants to ask the jurors any questions, either from yesterday's panel or today's panel, any concerns that he may have about any of them.
I would agree that that's a good procedure to employ, Mr. Brooks, so you'll be given that opportunity. I would note he does not have the headset on here. I can make a further record that previously especially when I went through the waiver of right to an attorney, I realized that was in this courtroom, but he at times would answer, I hear you, or I heard you. But Mr. Brooks, you're advised that if there are any follow-up questions on anything you didn't understand or you believe you didn't hear, we will have all of the jurors at one point that are remaining from yesterday and today brought in the courtroom. All of them have numbers, and you'll be able to do follow-up that is appropriate. Now, you also mentioned previously when I referenced going back to your cell to get the list. I'm giving you that opportunity. You asked me to do that.
I did not ask you to do that. The question was, where was the list at?
That's true. So you said the list was in your cell. I'm advising you that I'll give you the opportunity to go.
I don't want to do that.
Can I finish? I'm advising you that you are being given the opportunity, if you so choose, to go back to your cell to obtain the list of witnesses that you have been working on. Further advising you that if you choose not to do that, your one option would be to verbally tell the court any additional names to what you've already provided. Write those down for the court so that either tell me now or write them down so that I can include them in the list of names I'm providing to the jurors.
So how am I supposed to do that without the list in front of me?
The list that you have in your cell?
How am I supposed to do that without the list?
I'm telling you, I'm giving you the opportunity to go get that.
I'm not going to go do that.
Mr. Brooks, I'm not going to play games with you. I'm giving you an opportunity.
And I told you
You
that
either go to your cell and get the list or not.
You said I have the opportunity to do that. You said I have the opportunity.
I'm not going to demand that you do it, but you have to understand, sir, that if you choose not to do that.
I don't understand. I don't understand.
All right,
I've made that clear. I don't know how many times.
You claim to not understand, and that's been made very clear.
I don't understand. You're not going to get me to consent to something that I don't consent to or agree to. I do not understand.
All right.
Just like I don't
we're going to
understand
take
the
a
nature and
recess
cause
so
of
that the court can get this information
exactly like I've
on
been
the
telling you
state.
from the beginning.
Okay, he's continuing with his disruptive behavior. It is his choice to do that. Mr. Brooks, you are hereby warned once again, if you continue with that, you will be removed from the courtroom.
Remove.
Requesting to go to the other courtroom?
Remove me. I told you that before I even came over here.
Sir, are you requesting to go?
I told you that before I even came over here.
Mr. Brooks, are you
that
requesting?
It was pointless of me to come over here. You can smile all you want and think it's funny. I don't. I don't take this as a joke. I don't take this as a game.
My preference is for you to be
You
here.
expect me to answer all these questions that you have for me, Your Honor, but you have yet to answer one question that I've asked you. You have yet to verify anything.
You can take them back to the other room that has been disrupted.
You haven't even honored my request to make an offer for my appeal.
Thank you, ladies and gentlemen. We'll have to clear the courtroom.
I don't agree to a stop when I move this court for a motion to dismiss.
The record should reflect
The record should reflect that my rights are being trampled on. This is ridiculous, man.
Okay, this right here is audio from the other courtroom that we didn't see him, but it's just the audio. Somebody left the mic on. Hot mic.
As soon as I raise the issue, I'm being disruptive. I'm intentionally trying to be disruptive. I'm intentionally doing this. I'm intentionally doing that. So I should have just stayed over here, which ain't even legal to do anyway. Can't be present and not present when it should be a motion. This is ridiculous, man. This is ridiculous. You're forcing somebody to agree to something that they ain't agree to. Y'all come up with anything y'all can. Anything y'all can. Why I need that in here? You could have left that over there. I'm going back over there anyway.
Just in case.
If I'm right here in front of the face, I don't have no problem hearing. That's why these could have. I'm gonna have to go back over there. Y'all know that.
We'll bring it with us.
I'm just saying, man, this is ridiculous, man. This is ridiculous.
Excuse everyone from the courtroom, take a recess so that the test result could be obtained and if necessary by reasonable
COVID
force.
results.
It's my understanding there was some type of situation or altercation between Mr. Brooks and the deputies. Ultimately, though, I think he was taken into the bullpen. He was brought back out, but it was very clear to me that he was upset. I think understandably so, but I needed to make a record of what was being done, including that I have obtained the test result, so there's an accurate record in this case related to the motion that was raised previously by Mr. Brooks. I want Mr. Brooks to know that I am not removing him from when the jurors are brought back in. It was just simply because he was upset. He was very loud when I walked into the courtroom before going on back on the record. He was yelling about his constitutional rights being violated. I advised him that if there was any type of use of force that he wanted to complain about, he could certainly do that through the proper channels with the sheriff's department, but just given his state of agitation and my need to make a record, I had him taken to the other courtroom. He is currently muted. I do not intend to go forward with additional testimony. Ultimately, I'm going to take an early lunch break because of this, but I will make a record of the following. I have the result. I am going to scan it, have my clerk scan it. It will be filed as confidential, though. It won't be available to the public, but it's there for appellate purposes, but I can confirm that the test result for COVID-19 was negative. And again, I required the sheriff's department to provide that result to me, and it was, and it will remain under seal. I realize I'm disclosing that result, but I feel obligated to do that given the motion that was raised 2 days ago by Mr. Brooks. Again, I intend to take an early lunch, so that will hopefully give Mr. Brooks an opportunity, if he so chooses, to review the result himself. It was put in front of him. I did see that he either shoved it or tossed it or just dismissed it. It looked like it went on the floor when it was put in front of him, but we'll certainly have the deputies give that to him again. During the recess for lunch, Mr. Brooks will also be given the opportunity to change into street clothes if he so chooses. But when we come back, he will be in this courtroom. I agree. Mr. Brooks was making a couple of statements about how he was abiding by the rules and being respectful, things of that nature. I agree. He's done an excellent job while in court here this morning. He's been respectful of the rules. He made some early on. I let him, make his objections or lack of consent. He did that respectfully. When I said I was moving on, he generally was able to do that. We were able to get through 2 witnesses. He was able to follow along, ask cogent, clear,
Here comes the crying.
responsive and articulate objections. He was able to elicit information from the witnesses regarding either their memory, their credibility, and other things. Generally speaking, he's been able to competently represent himself and provide, again, solid cross-examination this morning. So I'm going to give him an opportunity to hopefully settle back in and to come back here when we return from lunch. So with that, we are in recess. Probably come back at 1 o'clock, since it's only 11:30, and we'll take the full 90 minutes for lunch today. Thank you.
Oh, poor
We are-
thing.
Let's get all of our audio on. All right, we are back on the record. It is 1:07 p.m. Appearances are as they were previously. Mr. Brooks is in the courtroom. He is in jail attire, as that is his choice. And I don't know if there's anything the state wants to address at this point before we continue with testimony.
No,
Just
thank
wanna
you.
check. All right, Mr. Brooks, anything you want to address at this point? It's hard for me to see his head. He's bent over, but I thought I saw him shaking his head. No, but I'll ask one more time. Mr. Brooks, anything you want me to address before the jurors are brought out to continue with testimony from witnesses?
Just a little emotional right now.
All right. Let's bring the jury out. We'll continue. I
Happy
presume the state
birthday,
has a
tall
witness in the
glass.
room. We do. All right. Thank you.
Hey, Casey. He's emotional because it's about him.
Mr. Brooks, the jury is headed out, but why don't you hold off on that, and at the next appropriate time when they're not on their way in, I can address whatever it is, or if you want to pass me a note, you can do that as well.
Oh, he gonna write a note. Jason's putting us all on notice to have a happy 2024. That's funny. Oh, that would tick him off big time, Judy. If Erica got up and said, "Oh, guess what? They're not your kids." He can't stand it when it comes to her.
Tell me the topic, we can cover it verbally.
The topic is pertaining to exculpatory evidence. Some things were learned, and once they came to my attention, I felt the need to immediately address the court about this information.
All right, what information make an offer of proof for me, sir?
The expert witness for the prosecution in regards to, I believe it was inspecting the vehicle, Officer Ryan Schultz. Question was asked of, did he know if there were any recalls on that vehicle? And I believe that a Brady claim should be visited because there were in fact recalls on that vehicle. In fact, there were recalls on the Ford Escape models from 2008 through 2010 in regards to the throttle body malfunctioning and causing the vehicles to accelerate and not being able to be stopped. There is a class action lawsuit where Ford Company were sued because of this, and those vehicles models from the year 2008 through 2010 were recalled. And that is very important information in regards to the vehicle in question being a Ford Escape 2010. This information is very easily obtained just by pulling it up, and you will see a class action lawsuit. Obviously, if it's a class action lawsuit, then it's pretty easy to.
So what's your request, sir?
My request is to find out if Officer Schultz knew, to find out if the prosecution knew that there was a recall on those vehicles, and in light of the fact that these vehicles were recalled because of this malfunctioning throttle body for I believe it's counts 1 through 73 to be dismissed.
All right, what's the response from the state defendant?
Thank you, Your Honor. As Trooper Schultz testified during his examination, consistent with our research, there are no active recalls listed for the Ford Escape. As Trooper Inspector Schultz noted during his testimony, that Ford listed an extended warranty for the throttle body on the Escape. The warranty was extended to 10 years of age and 150,000 miles. The Escape is more than 10 years old and has more than 150,000 miles. Also, he noted specifically in his report that he did not note any defect in the throttle body as previously described in this report. There was no recall in the throttle body. NHTSA did do an investigation into allegedly defective Ford throttle bodies, which would have impacted this year. Basically, the electronic throttle body failures would have resulted in engine stall or surge while entering traffic from a stop position or while driving at highway speeds, neither of which I believe occurred here. Further, Inspector Schultz would testify that that does not prevent the brake from working. So if this had been activated on this car, which it was not, but if it had been, and this defendant would have pushed down on the brake, it would have stopped the car. Further, if this was a problem, there would have been the malfunction indicator lamp or the wrench light would have been illuminated, as Trooper Schultz or
Inspector Schultz testified when he started the vehicle and checked the indicator lights, none of them were lit. Further, if there was this, he would have observed material buildup on a commutator. There was no such buildup observed. There were no problems with the throttle, electronic throttle body. That was part of his report. Therefore, this is, although there may have been some cars who had this problem, the car that the defendant was driving on this day did not have that problem.
In other words, no. Nice try, but no. Mary Carol Hooper, thank you so much for becoming a member, and congratulations to KC, Noreen, and Tall Glass for your anniversaries on the channel. Budgie Girl, that's so kind of you, honey. Thank you so much. I appreciate you. And also Miss Patty. Thank you so much, Miss Patty.
That was testified during the vehicle inspection. The defendant had the opportunity to cross-examine Inspector Schultz with regard to that. And again, in running the defendant's mom's VIN number through NHTSA, National Highway Traffic and Safety Administration, there are, for this particular VIN number, for this car that the defendant was driving, 0 unrepaired recalls. So it's a moot issue.
I don't believe it's a moot issue, and I actually have, the report should be in the mailroom as we speak. I had everything sent over priority mail, the actual information about the class action lawsuit, the actual information about the recalls for those models. Like I said, 2008 through 2010. Now, in all fairness, Your Honor, that's why I was asking for a Brady claim on this. Seeing as how when vehicles are purchased from the manufacturer, they're still sold as is. There would be no way to know that there's anything malfunctioning with the vehicle until it actually happens. And seeing this a class action lawsuit, no one would sue the Ford company if there weren't malfunctioning vehicles. There would be no class action lawsuit if these vehicles were not malfunctioning. And I believe with that, like I said, the information is easily obtainable. I should have the information in the mailroom right now that you can readily view this information about the class action lawsuit, about the recall. It wasn't just the 2010 model in question, it was 2008 through 2010. The information about the malfunctioning pertains strictly to the throttle body.
Let me address your claim, sir. So, not trying to cut you off, I don't need the specifics about a class action, because as it relates to this case, the fact that there's a class action would not mean there's a Brady violation by the state. In fact, you even indicate it was readily known and something you were able to find out. I'd further note that you had a full and fair opportunity to cross-examine the inspector regarding his mechanical inspection. It's not new information. And more importantly, as it relates to this particular vehicle, based upon the testimony of Inspector Schultz, it's speculative as to whether this vehicle would be impacted, number one, by the class action, and number two, any throttle body problems. because, again, there was a full inspection. That report was provided to you. He testified on direct examination about there being no active recalls, and more importantly, he testified about what impact the throttle body would have and what he would expect to see if there were any issues with it.
Now to that exclusive jailhouse interview. Prosecutors say he took deliberate steps to maximize the carnage when he targeted families as they celebrated Christmas. But if you think the suspect in that parade rampage is a monster, he's got a message from behind bars. Words hurt. In his first comments since the attack in Waukesha, Wisconsin, the suspect is complaining to Fox about being demonized as he sits behind bars.
Brooks told our reporters, "I just feel like I'm being monster demonized." He answered questions, but he did not explain why he attacked all those innocent people at the Christmas parade. Brooks explained that no one, not even his mother, has been to see him at the jail.
Darrell Brooks's mother is sharing her opinion on the verdicts today. 12 News' Caroline Reinwald spoke with her, and she joins us now live. Caroline.
Joyce, she tells me the trial has been different.
Okay, you guys in the chat that aren't getting along, just watch your tongue, please. I know that not everybody's going to get along. I know we all have different opinions and everything, but I really enjoy all of you guys being here, and I do appreciate you have different opinions, but just stay off of each other's backs about what everyone's opinion is, because that's their opinion. They're allowed to have it, and they're allowed to put it here in the chat. So please be nice to one another. Y'all gonna make me go all mom, and it's New Year's Eve, and I don't want to go all mom. For crying out loud, Barbara Seals just gifted 10 memberships. Thank you so much, honey. You're so kind. Thank you.
Difficult for her to process. She also says her son is mentally unwell, though she did share her thoughts for the victims and their families as well.
The hate was stopped, the hate mail was stopped, the hate emails that I'm receiving was stopped, you know, and people's hearts began to heal. My heart still goes out to the family. My condolences to all of them, but I hope that they can begin to heal.
My condolences, but
Dawn Woods, the mother of Darrell Brooks, says she did not watch the verdict live today, but learned from loved ones of her son's conviction and says she's not surprised. When your son said that he didn't mean this wasn't intentional, did you believe him?
I know my son. I know it wasn't intentional. People who are mentally ill need help. In the community, family, loved ones, the court system need to give them the help that they need.
Now, Woods tells me that she did speak with her son today, though she would
Anybody
not tell
wanna
me
puke?
exactly what they talked about. She says that needs to stay between a mother and son. Joyce.
I asked Darrell Brooks's mother, Dawn Woods, about how she felt about today's verdict. Her son found guilty on all counts.
Do I think it's fair? No. You know, I don't know why they couldn't go into concurrent sessions instead of just, he would not live 6 life sentences.
What do you think he should have gotten?
I don't know what they just say he deliberately killed those people. He did not deliberately kill those people. It hurts more than anything.
What do you think he's thinking? Have you talked to him?
I
you
did,
talk to
but
him?
I won't share.
Okay. Did you talk to him yesterday?
No, he called me today after he got out of court. We talked briefly.
We also discussed how she plans to move forward now that she'll only see her son behind bars.
Hopefully, this will bring awareness to mental illness via our senators and our governors and elected officials, court, police. Very little help is done for individuals who are incarcerated with mental illness.
How do you feel right now?
Right now, I just want to curl up and die.
no, not one tear, Lenny.
That's how I feel right now. I just want to go somewhere. Just curl up.
She knew he was
But I
dangerous,
can't.
So she's just going to
As
let
long
him
as
out.
my child is alive, I have to stay alive.
So why did she let him out? If she knew he was danger, if she knew he was mental, obviously, why did she let him out? It makes no dang sense, you guys. It makes no sense whatsoever. Because she knew that. I almost feel like it was dumb for her to do that, like for herself, because I think she was scared of him. He ran all over her too. Thank you, John Anna. Oh, yeah, I think the chat's just I don't know who's being pissy tonight. I'm not sure where it's coming from. And I'm not pointing fingers at any one person, but I'm just saying if y'all are going to talk back and forth to each other, just make sure it comes out right. Because sometimes when you type it in the chat, it doesn't sound the same way as when you type it. If you know what I mean. If you know what I mean. If you don't give a damn, then Crazy Casey's just going to boot you. And that's all there is to it. All right, we're not done yet. Wait, I want to hear this one more time. Listen, y'all. Listen to this.
The court will call State of Wisconsin versus Darrell Brooks, case number 21 CF 1848. May I have the appearances, please?
Good afternoon, Judge Sue Opper, Leslie Basie, and Zach Wichow, appearing for the state of Wisconsin.
Good morning, Your Honor. My name is Darrell Brooks Jr. My name is Darrell Brooks Jr. Say my name. Darrell Brooks Jr. I'm in the say my name. Darrell Brooks Jr. It is by special appearance. No grounds. Okay. Did you speak to the complainant of the domestic allegations at that time?
Objection. The use of the word complainant.
Sustained as to the form of the question.
That question wasn't answered, but okay.
That dang Seelan. If Seelans could talk.
So there'd been the subpoena sheet that would have had your name and a number of different.
What do you mean my name? What are you referring to?
I believe it would have said Darrell Brooks on it.
Are you aware that I don't identify by that name?
Objection, argument.
Sustained.
Sorry.
What do you mean by complaint?
The complaint would be a reference to the charges in this matter. So is that what your subpoena said? Was that the language of your subpoena? The logistics?
We've been down this road under 906.11, Mr. Brooks. I need you to ask a relevant question to this witness.
That was relevant. He said what was on his subpoena.
No, you've talked at length about the subpoena. So under 906.11, move on to a new topic, please.
Also believes that you could always use communication when you need to delay.
I know you're holding up your objection sign, sir, but I am giving you the opportunity to come back over here. Would you like to come back to this courtroom? Record should reflect he's holding up his objection sign. It appears that he's writing, I don't know what, of course. Mr. Brooks, I'm going to ask you again. Would you like to come back to this courtroom for opening statements?
So I'm on the record.
You are. If you would please address my question.
So you want me to come back over there just to get brought back over here?
That's not what I asked you, sir. I told you, I advised you I would like you back here. It's always my preference that you're here. You demonstrated previously that you can follow some rules. When the jury is present, the jury's going to be brought back in shortly for opening statements. The state will go first as they bear the burden of proof, and then you will be given an opportunity to also present an opening statement. So my question to you is, do you want to come back to this courtroom, sir?
so I can get sent back over here, because as soon as I say something, I'm gonna get sent out.
If you follow the rules of decorum and courtesy and civility, you will remain. But if you choose to
You're
not
saying
do
that.
then you run the risk of once again forfeiting your right to be present.
You say that even though I never consented to being taken out. You say that everything is about the decorum and all this. That's what you say. But when I'm raising issues of understanding, which I keep telling you I don't understand, then it's looked at as being disruptive. It's looked at as intentionally trying to be disruptive. And I don't understand why everything I say has to have some type of disruption title to it. It's even been put on record numerous times with inaccuracy. Even what happened today, nobody reported on record about me being bruised up and having to get bandaged up and all these things, but it was put on me, laid at my feet, as if me, quote unquote, being disruptive was deserving of what happened to me. I'm simply trying to have a fair trial. And if I don't, forgive me for being this way, Your Honor, but if I don't understand, I'm going to ask questions. That's the only way I can have clarity, is by asking questions. And you have refused to answer anything, but I have to answer everything you ask me. Where's the give and take? It should be fair. I'm not asking for legal advice. I'm not asking for nothing like that. I'm asking to simply have clarification so that I can understand. I cannot put on an adequate defense if I don't understand something. Do you see these boxes I got right here? Do you think I was able to go through everything in those boxes?
Mr. Brooks, I'm not going to go through this with you again where you attempt to put on the record all of these issues that you have when we're in the middle of a trial. All right? You willingly waived your right to an attorney. I made all of those findings, so we will go forward.
You made those findings,
I
but
am
they-
not obligated to answer questions.
You made
when
those
you ask me
filings.
questions, I'm going to mute him.
Yeah.
I am not obligated to answer questions that explain procedure or the law. I am obligated to address motions to address that are based in law and fact. I'm obligated to address objections, for example, whether it be to testimony or evidence or questions posed to witnesses. But I am not obligated, sir, to provide you with an explanation of the law, of the procedure. And with that, since I gave him 2 opportunities to answer a very direct question, and that was, do you want to come back to this courtroom? And he chose not to answer it, but instead ask a question and then start making statements about his lack of understanding. I will find that his non-response, that he has not answered directly, which is willing to follow the rules of decorum and courtesy and civility, and without such a pledge, he will remain in that courtroom. He's muted. The record should reflect. It appears he's talking as well. He's making hand gestures. His lips are moving behind the mask. And I just wanted to make a record of that. All right, then we will have the jurors brought in, and then the state can then proceed with its opening statement.
We see these boxes right here. This box
Lord.
alone is 45 or 50 pounds full of so much information. I haven't even gone through half of it. It was stated for the record that the discovery, in its entirety, was brung to my housing unit on the 29th of September, which trial was scheduled, that would be a Thursday, which trial was scheduled for Monday. How can I possibly go through all that, all the paperwork, all the digital discovery and things of that nature? How can I go through all of that
and be prepared in 3 days.
Court must also advise you that I can make no guarantees about your access to legal materials while in the jail. Did you hear me advise you of that?
Yes, I did.
That's a clear bias. I did not have time to prepare for this. Everything I'm doing is off the top of my head, winging it, taking it as it comes, when the court is well aware that I was not prepared.
The court is further advising you, sir, that this trial will start next Monday, October 3rd.
I raised the issue that it should be an adjournment, at least at the minimum, it should be an adjournment because of that fact, at least to let me go through all the discovery. That was denied. No valid reason was stated for that when Your Honor knew there is no possible way, humanly possible, that I could be ready for a trial of this magnitude in 3 days.
So here's the important takeaway, in my humble opinion, sir. You are being advised that I am not going to adjourn the trial that is scheduled to start next week. Did you hear me say that?
I heard you say that.
And as we sit here today, I'm still not even understanding the nature and cause of the charges. That hasn't even been proven.
Are you further informed that all of this conduct primarily relates to what has been referred to as the Waukesha Parade incident?
They worded it as a different way. They call it an attack.
I don't know who they is, and I don't frankly care.
If every valid argument that I raised is taken by the court as a sign of disrespect or a sign of trying to intentionally be disruptive or causing a problem, when I'm merely seeking understanding, because I don't understand. I'm merely seeking to understand why this information has yet to be provided and we're this far into this matter.
Advise, sir, that the judge, that's me, cannot be your attorney and cannot give you any legal advice. You are further advised that the district attorney cannot be your attorney and cannot give you legal advice.
Which brings me to the motion to subpoena witnesses. I did everything that was asked of me by the court pertaining those subpoenas. It was understood by the court that this is my first time ever having to do this. I didn't understand how to properly fill out the subpoenas, at which the prosecution volunteered that they would give assistance. The only assistance I received was for them to check to see if it was filled out right. That was it. That doesn't amount to any assistance. I was still left to fill it out on my own, and then when I did that, corrections still had to be made, which would verify what I was saying. I don't know how to do this.
You are further advised that the judge, district attorney, and court personnel are not required to explain court procedures or the law. You are further advised that the judge cannot treat you any differently because you do not have an attorney. You are further advised that you will be required to follow all legal rules and procedures that an attorney would have to follow in court, and that it may be difficult for you to challenge evidence presented by the district attorney if your case goes to trial. You are further advised that it may be difficult for you to present evidence. You are further advised that if you want to testify, you must be sworn out as a witness and answer questions from the district attorney. You are further advised that it may be difficult for you to do a good job as your own attorney. Did you hear the advisements that I just read to you, sir?
Yeah, I heard it.
Obviously, the court knows that I'm not privileged to the same filing system. Which brings me to the reason why I brought up the issue of assistance of counsel. Under the Sixth Amendment, I have the right to assistance of counsel. It doesn't say anything about representing yourself without assistance of counsel. Having counsel represent you and having assistance of counsel is two totally different things.
Why did you not check this box?
Because it is my understanding that representing myself pro per, I can have standby counsel. So that, in a sense, is why that box specifically is not checked.
That is not a correct statement of the law, sir.
You, Your Honor, gave me paperwork that was a waiver of counsel. We both know that any contract can be altered if I don't agree to certain terms. I crossed out everything in that paperwork that I did not agree or consent to, and specifically wrote on that paperwork that I do not waive my right to assistance of counsel. At the very least, I should have been awarded a standby counsel.
Mr. Brooks, the case law makes clear you cannot act as your own attorney, right? Exercise your right of self-representation while simultaneously exercising the right to counsel. Did you hear me say that?
Yes, I heard you say that, but that wasn't what I was attempting to do.
Not someone to represent me, to speak for me, but someone to help me do things in a timely fashion. Get things filed in a timely fashion. Get motions together in a timely fashion. Make preparations to get things done that I don't have the privilege to do in my current situation of being housed at the Waukesha County.
Who peppers their rations? I have never peppered a ration ever. I've never, ever peppered my ration.
Jail.
It is my understanding, sir, that based upon the motion that was filed, the waiver of attorney form that was filed, and the proceedings that have been held over the course of the last 2 days, you wish to represent yourself.
I wish to represent myself pro per, but I do not wish that my entire Sixth Amendment right not be honored. I essentially would only be agreeing to the part where I want to represent myself. Just that stipulation of my Sixth Amendment and no other stipulation of my Sixth Amendment.
Your Sixth Amendment right to counsel is pretty straightforward, sir. You have the right to an attorney. You have the right to represent yourself. Those two things don't always go hand in hand. In fact, never go hand in hand.
But yet, I'm still forced to come in here with zero help.
You will have the sole responsibility to cross-examine witnesses, to present evidence, to make arguments to the court, etc. Did you hear me say that?
Yes, ma'am.
And you're informed of all of that?
I am informed.
Any questions regarding that?
Not at all.
I think it's clear that prejudiced my defense. Knowing that the prosecution has everything that they need for this matter at their fingertips. And I have to jump through every hoop possible to even get things filed in a timely fashion. It was stated for the record that the unit that I'm housed in the Waukesha County Jail, and per jail administrator Angela Wallenhoff, that I'm only allowed out of my cell for a few hours a day. So I'm roughly locked down 22 hours a day. Not given the privilege to access everything that I should be able to at the time that I should be if I was general population. Arrangements could have been made months ago for me to be at least in some form general population with an upcoming trial. Reference was made to being able to use LexisNexis or whatever it's called. We call it the law library. That may be the easier way to describe it. I'm only allowed to access the law library at certain times during the day. The rule of the jail is that when you're not in the day room, you can't access the law library, which is on tablets. We are not allowed to have those tablets in our cells. That prejudiced my defense. How can I work on my case? How can I look up certain case laws? How can I do any of this if I don't have full access to it? I even suggested some type of order that could be made by the court to allow me more time out of my cell, or to talk to jail administration about allowing me more time out of my cell to be able to use those when needed. And to be frank, in a proceeding of this magnitude, there should not be even a time where I don't have access to the materials that I need.
Don't be blaming Frank.
If I'm not in the courtroom or sleeping, I should be awarded the time to work on this case, seeing as how I only had a couple days to prepare for a trial of this magnitude.
I'm the jail administrator for the Waukesha County Sheriff's Department. I am head of the division in charge of all staff and inmate issues.
Although Mr. Brooks is under a COVID protocol, is he still allowed to review his discovery materials in his jail cell?
Yes.
To your knowledge, are those materials?
The objection is overruled.
I'm sorry. To your knowledge, if you know, are his discovery materials currently in his jail cell?
Yes, ma'am, to the best of my knowledge.
Okay. Is he still
I object
able?
to that, Your Honor. I'm not allowed
Sir,
to
her
keep.
answer stands. There's no question to which to
I
object.
object to that. There is.
You can't testify at the moment. If you want to provide further information after she is done testifying, I will give you that opportunity.
Will she?
Your
will she be
objection
able to-
is overruled.
Will she be able to stay right there so I can ask the question?
It's not your time yet. You have to wait. So this is the final warning. Okay, I've given you a lot of leeway today.
You have not, Your Honor. You haven't. No.
I am turning to Attorney Opper. It is her opportunity, her turn to ask this witness a question.
And it is my right to be able to object, just like she objected when I was asking.
Right. When the court rules on an objection, usually the party who objects stays silent. I rule on the objection.
Usually.
The parties don't debate the ruling. It's noted for appeal. And then we move on.
Then I would like to put you on notice that I will be appealing that judicial decision that you are making.
Next question, Attorney Opper.
The judicial determination.
Ms. Molenhop, while on COVID protocol, does Mr. Brooks have access to the tablets in his jail cell?
Yes, ma'am.
And that tablet has legal materials available for him to access if he so chooses, is that correct?
Yes, ma'am.
And while he is on COVID protocol, does he have access to the conference room, which also contains a computer with further legal materials?
Yes, ma'am.
And thank you. So, Ms. Wolenhop, I was asking you about the digital discovery materials. You testified that you're aware there is a thumb drive available for Mr. Brooks' use that is maintained in his pod, and all he has to do is ask for it, correct?
Correct, ma'am.
And that in order for him to view the contents of the thumb drive, he'd have to use the computer in the conference room, correct?
Correct, ma'am.
And that is available to Mr. Brooks upon his request, correct?
Correct, ma'am.
And nothing about this protocol then would limit his access to any of his discovery materials, correct, ma'am?
Objection.
Overruled. She may answer.
Correct, ma'am.
And he would have access to the telephone if he wants it.
Objection.
Overruled. She may answer.
Yes, ma'am.
And there would be nothing that would restrict his ability to come to court each day?
Objection.
Overruled.
Correct, ma'am.
And when he comes to court each day, he has the ability to bring whatever discovery materials with him that he wants. Is that correct?
Objection.
Overruled.
Correct, ma'am.
And in fact, there's a card available for him to do that if he so requests.
Objection.
Overruled.
That is correct, ma'am. Correctional officers would transport it, but yes, there's a card available. Sure.
And you stated that you read the report after you submitted it. Do you know how long it was before you were able to see the report that you typed?
Objection, relevance.
Grounds?
Sustained.
Well, he already answered that.
Then I'll object as asked and answered, Your Honor.
Sustained.
That question wasn't answered, but okay. Do you recall when you typed your report?
Objection, relevance.
Grounds?
Sustained. Not relevant.
How's that not relevant if he already answered that he typed a report?
Please continue, sir.
Mind-boggling.
Grounds for the sustain.
Relevant.
He answered that he typed a report. So how's it not relevant if he recalls when he typed it? From your testimony, it seems like you've been doing crash reconstructions from quite some time. Is that fair to say?
Yes, sir.
You said normally you don't put the speed calculation in the diagram. Would it be any reason for that?
It's in the report. It's not necessary to put it in the diagram.
Have you ever done that before?
Could you rephrase the question?
Have you ever not included the speed analysis in any crash reconstructions that you've done before this one?
Are you referring to the diagram or are you referring to the report?
Referring to the diagrams.
No, I don't. I do not put speed calculation results in diagrams.
On any of them?
On any of them.
Did you create any diagram with the speed calculations present on it?
No, I don't. The diagram that I created is the one that was up on the screen.
And then from there, you put the speed calculations just in the report.
Yeah, I normally just put them in the report, yes. I don't have any recollection of putting one in the diagram.
Would it be fair to say that it may be a little bit difficult to locate what you analyze for speed if it's not in the diagram?
No.
So if you wanted to know the calculation of the speed, you would have to read the report.
Correct.
Would it be fair to say that it might be easier to find if it was included in the diagram?
My diagram is included with my report, and that's all one unit, so it is in the report.
You made reference to something called Newton's Law. Can you explain a little bit further what that is?
Newton's laws of motion are what we use as a big step in our reconstruction field. A lot of formulas are derived from Newton's laws, including the formula that we use to calculate the vehicle's average speed. Sir Isaac Newton obviously invented the laws of motion. We all learned that in high school, and that's part of the process that came to the formula that I use to calculate the average speed.
I always thought of Newton as gravity, so that was a bit of new information.
That's one of my favorites. Okay, wait. Johnny and I mentioned the chocolates. So we have to talk about the chocolates. So let me open this up real quick. This is a D. Brooks School of Law video, but we just want to talk about chocolates tonight, so I'm gonna have to show it. So just one moment, please. Please hold. Welcome to the D. Brooks School of Law Training Manual video. In today's video, we're going to go over a couple of items that help Mr. Brooks. Now, we also have some video footage of Mr. Brooks in his own court case that you are going to find to be critical in your court cases. So we recommend you watch this entire video all the way through to the end. Now, Mr. Brooks is not guaranteed that these activities, these items, anything mentioned in the Darrell Brooks School of Law is going to get you off your charges, okay? What he does say is this is going to give you one heck of a chance. But you know what? In life, isn't that how it goes? We kind of all have chances. Before we get started, Mr. Brooks did have a message for all of you.
Ladies and gentlemen, I don't think it's fair to just say guys, but it took a lot of courage and a lot of guts to pause your life for this. I want you guys to know that's not lost on me. I'm sure it's a lot. And you all should be commended because it took courage to do this. I don't know, but I would bet a lot of people wouldn't want to be sitting in your position right now. Hopefully we got a lot of living ahead of us. Lord willing. Don't look back and kick yourself in the behind. Thank you.
Now, the first thing you're going to need before anything else is that Sovereign Citizen's Handbook. I don't know where you're going to get it, but you need to get one. Now, they might have them online. They might, if you're already in prison, you might can find one from somebody there that's already next to, maybe a cellmate or somebody that's not giving you a hard time there in prison. If you have friends in prison, they might have one. Okay. So, yeah. So let's start with our checklist. Now, Mr. Brooks does say that we should utilize all the items that the court provides for us. And you know what, people? These items are free. They're free of charge. So let's go through a couple of them. Now, Mr. Brooks, his court trial was in 2022. And as you guys know, COVID-19 was effective in 2020 when they shut down most of the United States. Oh, shoot, most of the nation for COVID. So what Mr. Brooks recommends that y'all do is go ahead and utilize that mask. I mean, go ahead and wear that mask. I mean, here's the thing. If you have shame because you're in the situation that you're in, that's just fine. But people are going to be taking all kinds of pictures of you. You might even be on video. So what we say y'all need to do is go ahead and put that mask on. It's going to help you. It's going to help you in the long run. And two, there might be some witnesses that come up that can't even recognize you because you got that mask on. Now, they might tell you take it off from time to time, but we're going to show you how to take it off, put it right back on. So y'all can watch this video right here and see that.
When he came out from the garage, he was asking if I could call him an Uber.
Okay. The person that you're describing for us, sir, do you see him present in the courtroom here?
He's sitting over there with the mask on and in the suit.
Okay, I'm going to ask the defendant be instructed to remove the mask. Mr. Brooks, please remove your mask. And if he would look at the witness, please, Your Honor, with his head down, it's not to assist.
Right, Mr. Brooks, please look up and look at the witness. Look at the witness, please. Thank you.
Now, the other thing is the prison Bible. You want to make sure that you take a prison Bible with you to court at all times. It can just be sitting there on the desk. It needs to be visible. You want to make sure you turn the book sideways so that the side of it that says that it's a Bible is facing towards the jury. And you just want everybody to know that you're a Christian person, or think that you're a Christian, because it might help. It just might help you. So just if something comes up and like what you're waiting for a real long time, what you can do is you can just pretend you're reading it. Heck, you could read it if you want to. It don't matter. But if you want to read it, you can. But Mr. Brooks really thinks that it's essential. It's essential in your case. All right. The other thing we want to talk about is when we're utilizing all of the items that are in the courtroom and around us, one of the things that we want to talk about is how the guards handle you, how they utilize different types of mechanical items or restraints against you. Now, Mr. Brooks had, in his case, he had a shock device on his ankles. He tells me this all the time. So I think where he messed up was that by not telling the court that those anklets were going off on shock devices all the time throughout the court. He was just taking that pain. He was taking that pain in, and he wasn't telling nobody it was there. He waited till the end, towards the end of his trial. So what he thinks that y'all should do is just go ahead, and every time they set that shock device off, you need to just jump at it and tell them, my ankle, my shocklet's going off. Now, if you don't have shocklets, or that's what we call them, shocklets. If you don't have a ankle device that's got electrical waves going through it to shock your body, then what you could do is you could just pretend that you do. And at the end, like say towards the end of the case, when things aren't going great, because it could be, because we don't make no guarantees here at the Darrell Brooks School of Law. But if your case is not going well and it doesn't look like you're going to be able to get off the charges, what we recommend that you do is state that those anklets, whether or not they are, state that they are shock devices. And you could throw a big fat tantrum in the courtroom and just go off, and we're going to show you right here how to do that. Okay? One moment.
Important to have a thorough record of the restraints that were utilized. The photographs that have been provided are on a compact disc. They will be filed as Court Exhibit 3, but they will remain under seal. And that is because of the security concerns related to how the Sheriff's Department secures inmates during a trial. That certainly is an overriding interest, overriding any public interest to see what those restraints are. And I would just further note that during the trial, when Mr. Brooks would be brought from the holding area into the courtroom, this courtroom was closed to the public. And that was really to maintain that privacy, if you will, or secrecy, if you will, regarding the restraint system. And so I believe it's important that that information not be released to the public. It will be available, of course, to the court and the parties. And if there is an appeal, any attorney that may represent you can certainly look at that, but it'll otherwise be under seal. So
Why would
the
that?
record is very clear on the restraint system that was utilized during this trial.
I have a question to that.
Okay.
Why is that remaining sealed, but everything else being open to the public?
I've indicated my reasons are on the record. I'm not going to restate them. So
well, I think that the public, if they're allowed to see search warrant information and things like that, then I think that they should know that it was a shock device on my ankles.
There was no shock device.
It was a shock device. I was told it was a shock device.
Mr. Brooks.
And it was covered up. It was covered up by a black cloth, so the jury purposely could not see it, and so that the public cannot see it. I was told that a chair had to be placed on my side so that no one can see that I was shackled with ankle shocks. I think the public should know that. The jury should have known that. That's what they were.
Mr. Brooks, I've made my ruling. Your
I
characterization
respect your
of
ruling,
those
but it
as
should be noted.
Your
it should be
objection is noted for the record.
It should be noted that I had a shock device on my ankles. That's fact.
It
It's
is
a
not
fact.
a fact,
It is a fact. I'm the one that had them on my ankles.
I inquired about what they were. Obviously, I'm going to require about what's being put on my body. I was told that there were a shock device, which I know how a shock device looks because I've been through this before in Milwaukee. So I know what a shock device is. It was clearly a shock device that was purposely not shown to the jury or to the public. Purposely not. And then now you're saying that it's going to be sealed. Well, why should it be sealed? The
All right,
public
Mr.
doesn't
Brooks,
deserve.
the
public deserves
you've
to
made
know.
a record,
The
and
public
it's
deserves
noted.
to know about
And
things pertaining to a search warrant, but not the fact that I was limited by a shock device. That if I moved the wrong way, I could have got shocked with all this voltage.
it's absolutely false that you
That
have a
is
shock
not
device
false,
on,
and
sir.
you know that it's not false.
Well, I have the photograph
Well, show
that
the
will be
where's
part
the
of the record,
photographs? Where's the photographs?
and they
You
will
just
be
said they would be sealed. Why do they need to
from
be
public
sealed?
view
Why
for
do
the
they need to
reasons
be
that I've
sealed from
already
the public?
indicated.
Why do they need to be sealed
Mr.
from
Brooks,
the public?
I need to move on to scheduling.
Can we move on to subject matter jurisdiction that hasn't been proved for the record?
All right, so
Can we move on to that?
Mr. Brooks, I really don't want to remove you from the courtroom today. But
I
I need to
don't
move
I don't
on
want to
to
be removed, but you're not going to sit here and tell me on the record what was on my body when I was told what it was. That's inaccurate, and I refuse.
At a
Your
later
Honor,
point in time, I
Your
will
Honor,
put.
I refuse to sit here and let you make an inaccurate record when you know that it was in fact a shock device. That's why I had the black cloth in front of the table so it couldn't be shown. That's
not
why I had
right.
a chair sitting on the side of me that was told needs to cover up the fact that I had a shock device on my ankles. And I think it's very, very, very unfair, and it's dishonorable to get on a record and not tell the truth. I'm not trying to dishonor you, Your Honor. I'm not trying to disrespect you. I'm not trying to disrespect your court. I just want the truth to be told. That should not be sealed. If everything else can be open to the public, then the public should know that I had a shock device on my ankles. That was purposely not shown to the jury or to the public. They should know that.
All right, thank you, Mr. Brooks. I disagree wholeheartedly with your
Well,
characterization.
it's not true.
Mr. Brooks, I didn't interrupt you. Please
It's not
don't
true.
interrupt me.
It's not true.
Mr. Brooks?
I'm quite sure there's cameras rolling right now because there are always cameras rolling. There's always audio on.
Mr. Brooks, I need
There's
to
public,
move on to
there's public in the
scheduling.
courtroom. I had a shock device on my ankles, and they purposely did not want to show that to you guys or to the jury. That's
Mr.
why I
Brooks,
can only move
I'm advising you.
here or here.
Mr.
That's
Brooks,
the
I'm
reason
advising
why.
you.
And I always had the chair right here. Everybody that came in this courtroom seen that I had a chair right here, even though I had no counsel. What is the reason for me to have a chair right here?
All right, Mr. Brooks,
Why did I have a black cloth
any
in front of
further
the table?
interruptions will result in you being removed to the other courtroom
Okay,
because
and
you're
you
not
hold
letting
me in
move
contempt.
on
That's
to
okay.
scheduling.
Is it civil contempt or criminal contempt?
All right, one more interruption and you will go to the other courtroom.
Well, they need to know that.
Stop.
They need to know that. They need to know the truth.
I'm going to ask the state some questions. If you interrupt when I do that, you will be removed to the other
Okay,
courtroom.
remove me then.
All right,
Remove me
Attorney
then. It's
Basie.
not gonna stop the fact that they need
All
to
right,
know that a shock device
he's
is on my
interrupted.
ankles.
I'm sorry, everyone. We'll have to clear the courtroom. He will be removed to the other courtroom. I'll
That's
make the
fine.
appropriate findings.
Tell the truth, though, Your Honor. Tell the truth. I had a shackle.
Lieutenant,
I had a shock device
Captain,
on my
can I
ankles.
please see you?
So these are the okay. Does he wear y'all out as much as he wears me out? Because I'm just, I mean, I know I'm sick, but still, that's just, Well, I just want to thank y'all for being here with me this evening, and I appreciate you. I appreciate you sticking by me, even though I have not been. I've had really low commentary tonight, though, because of my cold. But I put all this together, just fast-paced kind of stuff, and I hope you guys all enjoyed it. Thank you again to Crazy KC for moderating and being a member for so long, and for Brenda for becoming a member, for Mark for gifting memberships, Noreen for being a member for 2 months, and Tall Glass for being a member for a month, and Mary Carroll for becoming a member, and Budgie Girl for her super sticker, and Patty for her super sticker, and then Barbara Seals gifting another 10 memberships. You guys are amazing. And John Anna again for your super sticker. That chocolate was brought to you by John Anna, y'all. That was her specialty. All right, so on our way out, I want to play a little something for you guys. Let's have a little kumbaya moment together, shall we?
Should old acquaintance be forgot and never brought to mind? Should old acquaintance be forgot and days of old lang syne? For old lang syne, my dear, for old lang syne, we'll talk a cup of kindness yet for days of old lang syne. And here's a hand, my trusty friend, and here's a hand of mine. We'll talk a cup of kindness yet for old lang syne. For old lang syne, my dear, for old lang syne, we'll talk a cup of kindness yet for old lang syne. Should old acquaintance be forgot and never brought to mind? Should old acquaintance be forgot and days of old lang syne? For old lang syne, my dear, for old lang syne, we'll talk a cup of kindness yet for old lang syne. For old lang syne.
Thank you, B. Blanco.
Should old acquaintance be forgot and never brought to mind? Should old acquaintance be forgot and days of old lang syne? For old lang syne, my dear, for old lang syne, we'll talk a cup of kindness yet for days of old